My name's Louise Taylor. I'm an independent commissioner appointed by Environment Southland to hear and decide this matter. Welcome. Thank you for making the time to be here. It's really important for me to hear from all the parties who are interested, and so that I can make the best decision that I can make. In terms of process today, I have read all the papers, so thank you very much for those who provided evidence in advance, and I've read submissions and staff report. I've read those. When you have your opportunity to speak, I'd just ask if you just take me through the high notes of the things you think are really important for me to be aware of. I do have questions, so I will ask those. In terms of process, I will be talking a little bit about conditions. That doesn't mean I've got a view about whether this will be granted or not, but this is my opportunity to ensure that if I do decide to grant the application, then which conditions are appropriate to manage effects. So I will discuss conditions, but that doesn't mean I've got a view either way on whether to grant or not, because I don't. In terms of process, I think most of you have probably been to hearing before, but I do try and keep it as informal as possible, but there is a clear structure. There's no cross-examination. If you have a burning question for a staff member or for somebody, when it is your turn to present, you can ask me and I'll decide whether it's appropriate to ask that person. So there's certainly no chit-chat around between the parties in this forum. In terms of process today, we certainly should get done today, and what I'll do in a moment, I'll take appearances and run through the process. But firstly, I'd like to just check, are there any procedural matters? Right, thank you. In terms of order of things, hopefully you've got the indicative timetable handy. What we'll do is we'll hear from the applicant first. Ms. Lenehan, no doubt you'll be leading the case for your client. I do have some evidence, thank you, from Mr. McSorley and Mr. Cameron. So that's very helpful, thank you. We'll then hear from submitters. So can I just confirm which submitters we've got here? So we'll see some here. Great, thank you. And we don't have any evidence pre-circulated from you?
No, just the submission.
Okay, that's fine, thank you. And you, sir?
Video on Fiordland Guardian.
Guardian, thank you. And is Rebecca McLeod going to come in online?
Not sure, she's had a few family issues, so she's going to try and be here.
Okay.
Yeah.
No problem at all, thank you. Thank you for your evidence, I received that.
I think Mark's going to zoom in at some point. Mark Patient.
Okay, he's from Guardians as well? Yep. Okay, no problem. So the order will go, and just people at the back, are you just here to listen in? Not wanting to speak today? No? Great, you're very, very welcome. So the order of things, we'll hear from the applicant team. We'll go to you, Peter, next, and then Catherine, and then if I think Casmira may come from Tammy, we'll see how.
I've heard that she's coming in later.
She is planning to. Great, excellent. And then we'll hear from you, Brian, at the end. And then, of course, it's the applicant's right of reply, and we'll discuss at the end whether you want to do that in writing or whether we do it while we're here. In terms of a site visit, I generally do a site visit when I consider matters. This obviously is quite a remote series of sites, and I appreciate there's quite a lot of time and cost in that. So at the moment, my sense is that I won't visit sites, but if any party have a view that they think it's really important that I do, please let me know when you are having your turn to speak, and I'll make a call at the end of the hearing whether I do need to see the site, and if so, I'll discuss with the applicant about how to go about doing that. That's everything. Anything else? Great. Okay, we'll make a start on your hands. Thank you.
We should move there or stay here?
Up to you. Stay there. Let's no
Stay
trouble.
here.
Might as well stay there. We've got plenty of space here. It's great.
Thank you very much, Commissioner. Morena, ko Claire Linehan Maho. I'm Claire Linehan and I appear for the applicant. And today with me I have Mr. Blake Cameron, who's the General Manager for the applicant, and Mr. Luke McSorley, who's a consultant planner. Both of those people give presents today. So I think everyone knows in paragraph 1 what the application is for, and that the applicant is seeking preferential occupation of these 3 existing moorings so it can carry out its business, and that it's been limited notified, and there's 3 significants in opposition. And just jumping now to paragraph 5. So just in terms of the operation of the applicant, which I think is really, really important in this case, it's easy to lose sight of a specific application in these situations. So the applicant operates high-end small group tourism experiences in Fiordland and Rakiura, Stewart Island. And so they use the vessel, the Fiordland Jewel, which is a 24-metre 3-deck purpose-built catamaran with a high-quality 5-star marine fit-out, which provides accommodation for up to 20 passengers a night. And they've got various options of overnight stays, which includes in Milford Sound and in the remaining area alongside Fiordland National Park. Paragraph 6, so as you will know, Commissioner, the company operates via a coastal permit for commercial surface water activities, and this doesn't expire until May 2038. So it owns 5 existing moorings in the coastal mooring area, 2 of which are in Deepwater Basin and under current consents, and this relates to the remaining 3 of this application. And I think also importantly, all 3 mooring areas are located within identified anchorages in Appendix 6 of the coastal plan, and their placement is permitted under the plan. So use of moorings, paragraph 8. As set out in Mr. Cameron's evidence, FTL currently only operates in the area where the moorings are for 20 weeks a year, around 5 months, and he will talk to you a little bit more about exactly how that works, just because the detail wasn't in his evidence, became apparent after the submitters provided their evidence that there's still a bit of confusion about exactly how much time is spent by the applicant on those moorings and what else they do with the remainder of their time. So he'll elaborate, but I'll just go over that briefly too. So paragraph 9, so when the applicant is operating during those 20 weeks, on any given night, it can only use 1 mooring. So there will always be at least 2 moorings available for those 140 nights. And as I've just said, Mr. Cameron will explain the practical reality of one of their 5 or 6 night cruises in terms of, you know, where they're going to moor up. Quite often, depending on the weather, they won't be on any of those moorings. They'll be elsewhere in those areas, anchoring up or using another mooring. So, you know, there'll be even more potential nights available for other vessels to use. So paragraph 10, so for the remaining sort of roughly 7 months when the applicant is not in this area at all 3 moorings will be available for public use. So that's at least 7 months of the year, all 3 moorings are available for public use. So the majority of this time when the applicant is away from that area is spent in Milford Sound. And so that's where the applicant is now. In late October, the vessel relocates to Milford Sound and it operates there from the 1st of November until late April, and also operates in Rakiura. And so they don't return to the Southern Sound, they've just collectively sort of termed the area with 3 moorings out of Southern Sounds until May next year. And in amongst that, there's also 4 to 6 weeks of vessel maintenance. So I think there was some confusion in the staff report, probably in the application too, about, you know, for the rest of the time when the applicant isn't operating in this area, is the vessel going to be used by other people mooring up on these moorings? No, it's not, because the applicant is operating its business all year round on this vessel.
And are there any controls either via the existing consent, commercial consent, or the proposed conditions of this application that would put some parameters around those numbers?
So, well, yes and no. So the existing commercial surface water activity consent limits the number of trips that they can do, and so they operate in accordance with that. But I think it's more that it's the practical reality of what this applicant does. I mean, there's been a number of these sorts of applications, and none of the Mr. Hodgkin, sorry, but tongue-tied, can give you some more evidence about that. But my understanding is that none of those applicants have been limited to you can only use these moorings for 28 nights in a year. But the practical reality is that because of the operation of this company, they won't be using those more than roughly sort of 20 nights over those 20 weeks when they're in those southern fjords. Mr. Cameron can talk to you a bit more about that. Very helpful. So, moving on to paragraph 13 on page 4. Some of the vessels that are known to frequent moorings are the Southern Sounds commercial operators, the dock vessel, the Southern Winds, Otago University vessel, Seafin, and local fishing vessels. So moving on to the sites and the available space, and again, this is quite an issue for a number of submitters, including Environment Southland, about what actually is available in each of these areas. As Mr. Cameron sets out in his evidence, there's plenty of room in all 3 areas for others to anchor as and when required. However, often they are the only vessel on their moorings, with no other vessels in the same area at all. Only occasionally does the applicant share anchorage with others in these locations. Paragraph 15, Mr. Cameron notes Beach Harbour is the busiest mooring, but even in this space, there's still plenty of room for others. And Mr. Cameron has got some images which will assist you, hopefully, Commissioner, to illustrate this. So this is actually contrary to the level of usage noted in the Regional Coastal Plan, which was made operative a long time ago now, in 2013, so it's very out of date, which says that Beach Harbour has only light usage, which is contrary to the views of Mr. Cameron. In terms of other vessels, paragraph 16.
Can I just clarify your point there? So you're saying that Beach Harbour is the busiest mooring, but there's still plenty of space.
Yes.
And this is contrary to the level of usage noted in the RCP, which says it has only light usage.
Yes, which does, I realise as I'm reading that sound kind of counterintuitive.
And then you're saying contrary to the views of the submitters. So what's your position? What's the usage?
Okay, so the usage is very low.
Oh, so lower than light.
So no, overall, so there's 2 points here.
Yes.
One is that the coastal plan is outdated in terms of what it says the usage is, and the Beach Harbour example is, well, actually it's busier than the coastal plan says, but for the other 2 areas, the usage is less. But the point is that overall, submitters and Environment Southland through the Harbour Master are saying there's a scarcity of space and not enough room for people to anchor, thus creating navigational safety issues. And the evidence of Mr. Cameron is, well, that's not the case according to Fiordland Discovery, because they're in these areas, and when they're in these areas, they hardly ever see anyone else in there. Beach Harbour would be, a slight exception because that is busier. But irrespective, there's plenty of room in all of these spaces if and when there are people there.
Okay.
So at paragraph 16, Mr. Cameron has set out what currently happens if the applicant arrives at one of its moorings, and I think I can probably skip over that. And I just want to highlight, though, paragraph 17, which I think is really important, is that Mr. Cameron has noted if there is a situation of adverse weather in near darkness, the applicant would anchor nearby and not ask a visiting vessel who was already on the mooring to depart. And Mr. Cameron has noted the numerous benefits of being able to operate in the area. Paragraph 19, investment and maintenance. This is just reiterating what Mr. Cameron has said in his evidence. It's incredibly expensive to install these moorings and maintain them. There's a significant annual cost to the applicant to do this. So that's paragraphs 19 to 22. Now moving on to the issues raised by submitters, paragraph 23 onwards. Firstly, the Fiordland Marine Guardians. Paragraph 24, I note a statement in the FMG evidence that both authors of the evidence have been assisting Environment Southland with assessment of capacity of recognised anchorages in the area, Fiordland Marine area, and that their understanding is that the assessment will inform the new regional coastal plan. And the evidence also states the strategic direction the council is taking to review the rules and holistic management of the moorings and key anchorages is well known. However, there isn't any publicly available evidence about what the contents of any new regional coastal plan might be. In paragraph 26, I also note the recent amendments to the Resource Management Act introduced a prohibition on notification of any new plan until after the 31st of December 2027, unless there is an exemption. And notification, therefore, of any new regional coastal plan is over 2 years away, and it will then have to proceed through a public process, acknowledging there's another law change to come. I don't know what that's going to say, but this is just the situation as of today. So paragraph 27, at this stage, the information put forward by Fiordland Marine Guardians in my submission, you can't take it into account. It's too vague, there's no clear, it's not in the public arena, there's no provision under the Resource Management Act which allows you to take that into account. It's not a proposed plan, so in my submission it's not relevant for you to take into account. Paragraph 28, Fiordland Marine Guardians highlight inadequate mooring management by the council over the past decade and the associated risks on navigation safety, specifically the ability for all vessels in the region to find a safe haven in the event of bad weather, and the risk to accessibility for all users, and the carrying capacity for Fiordland being exceeded, it should be, to a point where, another typo, they're all coming out now, where the special character of the region is compromised. Oh dear. No evidence has been introduced about inadequate management of moorings by the council. And paragraph 30, the Guardians submit that due to the scarcity of safe havens in the Fiordland Marine area and increase in vessel activity, it's unwise to introduce preferential or exclusive occupation rights within recognised anchorages before a new coastal plan is operative. And to do so would risk preempting and undermining the goals of the plan with respect to occupation of the CMA, public access and navigational safety and environmental issues. And as I've set out above, there's no evidence has been produced to support any of those statements, including that there's a scarcity of safe havens in the areas where the 3 moorings are. All of the above concerns, including the carrying capacity of Fiordland being exceeded, are more appropriately dealt with by way of review of the coastal plan. I need to fire my editor, which is unfortunately not by this consent application. Moving on then to the next issue raised by the Fiordland Marine Guardians is insufficient information. Paragraph 33, the Guardians submit the application doesn't contain sufficient information, to example, determine the size and military, I'm not allowed to say that actually, of the anchorage, the space required for each mooring, and wider impacts in terms of room for other moorings. Mr. Cameron will also talk a little bit more about that when he speaks to his photos. Fiordland Marine Guardians note the explanation to policy 11.7.7.9. Let you read. And then paragraph 35, the evidence of the applicant is that in all 3 locations there is plenty of room for other vessels to anchor. All 3 moorings are available at least 7 months of the year. At least 2 moorings are available for other vessels to use when the applicant is operating on the southern fjords. Mr. Cameron will talk to you more about that. There are very good communication networks to enable almost instantaneous communication between vessels now, avoiding the element of surprise. And if there are adverse weather conditions in near darkness, as I mentioned, the vessel would anchor nearby and not ask a visiting vessel to depart the mooring. I also note the explanation to Rule 11.7.9, and the focus there is how much the degree of public use would be alienated. And in paragraph 37, in my submission, the degree to which any of the anchorages would be alienated is, well, I would say extremely limited, actually, given the evidence of the applicant. Moving on to exclusive versus preferential occupation. Quite a bit has been made of this issue by all of the submitters. Paragraph 38, the Marine Guardians consider the application for preferential occupation as a form of exclusive use and is in essence seeking exclusive occupation. The Guardian state it understands this interpretation has been tested through the courts but does not cite any case law it relies on. Paragraphs 39 onwards talk about the difference between exclusive and preferential occupation and the statutory proviso or provision for there being able to be preferential occupation, which of course is now in the coastal plan. So I just set out section 12(2)(b) under paragraph 39, which leads on to paragraph 40, the rule in the plan which provides for preferential or exclusive occupation. And then paragraph 41, very importantly, preferential occupation is defined in the coastal plan as allows the use of an area by the general public, except in circumstances where the person with the occupation right wants to use the area. And paragraph 42, just for the avoidance of doubt, I consider Rule 11.7.7.9 as lawful, as the Act itself contemplates degrees of exclusivity for occupation, and preferential is one of them. And I talk about that a little bit more. And the reason why I consider that is paragraph 44, the definition of occupy in the RMA includes the concept of lease or license, and they provide different levels of exclusivity. A lease is exclusive use, a license is not, although a license to occupy does, for practical purposes, grant exclusive use. But there are different remedies between those two in law. And the last sentence of paragraph 44, second last, between these two extremes could be preferential use, which in essence is a hybrid of some exclusive use and some not. This is what the definition of preferential use in the plan essentially is. And paragraph 45 just notes conditions on consents, and they allow you to impose certain conditions, and these can relate to coastal permits to occupy, which can detail the extent of exclusion of other people. And section 46 is really just sort of emphasising the point. So in paragraph 47, just to wrap up, although the labels lease and license are not used in this situation, what is sought is more akin to a type of license which does not include exclusive use. There is no exclusive occupation proposed for the area, and preferential occupation is not a type of exclusive occupation. It's either exclusive or it isn't. The consent sought is clearly stated to be for preferential occupation only, which is allowed by Rule 11.7.7.9 via a discretionary consent. Moving on to the next point raised by the Fiordland Marine Guardians, exclusive occupation of moorings and key anchorages, paragraph 48. The Guardians submit there is increasing vessel traffic in the region and implications for navigation safety. And the Guardians say Isthmus Sound has a limited capacity for holding vessels, whether on anchor or mooring. Paragraph 49, as I've mentioned previously, there's no evidence presented of increasing vessel traffic in the areas where the moorings are and the resulting implications for navigational safety. To the contrary, as I've noted, Mr. Cameron notes that many times there are no other vessels in the area at all, and only occasionally do they share anchorage in these locations with others, apart from Beach Haven, which is busier, as I've mentioned, but again, there's still plenty of space there for everyone. Paragraph 50, in terms of navigational safety, Mr. Cameron has also indicated there is contact information on the mooring and reasonably instant communication between vessels given Starlink. And Mr. Cameron states that if there is a situation of adverse weather, as I've said, they would anchor nearby. Paragraph 51, again, Mr. Cameron's evidence is there isn't a shortage of safe havens, but even if this was the case, as acknowledged by Mr. Hodgson, other mariners are able to anchor or install new moorings in recognised anchorages as a permitted activity to address any mooring scarcity. Moving on now to consideration of proposed plans at paragraph 52. The Guardians give the impression that a new coastal plan is imminent. As mentioned, there isn't any publicly available information regarding the contents of the plan. No plan has been notified, and the ES website is silent about timeframes. And paragraph 53 is just sort of repeating what I've said. And paragraph 54, I've already mentioned the amendment to the Resource Management Act about the prohibition on notifying any draft planning instruments. Certain exemptions do apply, paragraph 54, but I'm not aware if Environment Southland has applied for any of these, and Mr. Hodgson can let you know if that's the case.
Do we want to address that now?
Yeah, not as far as I'm aware. At this stage, nothing official.
Thank you. Paragraph 55, the RMA as it presently is doesn't allow you to consider the strategic directional goals in the way suggested by the Guardians. And paragraph 56, just reiterating that these issues are more appropriately dealt with in the Regional Coastal Plan review process. Paragraph 57, there are no resource management reasons highlighted as to why a shorter term should be granted for preferential use of these moorings prior to a new regional coastal plan. There is no potential for any adverse effects to increase, and it's not a case where there is any expectation that new information may come to light which might reduce adverse effects. And the applicant also makes a significant investment to ensure the moorings are maintained and makes these available to other users at no cost. Talk about that a little bit more later on. At paragraph 58, CRAE 8 submission, I won't read that out, Commissioner. Paragraph 59, I'll just note that the views of CRAE 8 are very similar to Fiordland Marine Guardians, and so the matters I've just noted in relation to the Marine Guardians are also applicable to the CRAE 8 submission. So paragraph 60, the reality is that the Regional Coastal Plan provides for preferential occupation of moorings as a discretionary activity. Fiordland Discovery Limited will not operate any differently in future with a consent to preferentially occupy 3 moorings than it does now. The reality in the fjords will be exactly the same as at present. The only difference will be the formality of resource consent, which will give some comfort to the applicant moving forward, given the significant investment it makes to maintain the moorings and the business it operates in the fjords. Paragraph 61, Te Ao Marama.
Just on that point, I'm intrigued, and I'll ask your client obviously, but if that's the case, why go through all of this?
Well, Mr. Cameron, we'll talk about that.
Yes.
Well, because there's, because I mean, I'm giving evidence, but because of the murmurings of some of the other parties. So this isn't the first time that these submitters have raised the issues that the coastal plan is, current coastal plan is not sufficient to deal with the issues they perceive in the coastal marine area in relation to moorings. And there's obviously some philosophical differences about whether mooring owners or anybody should have preferential rights to occupy moorings. So in the face of those comments coming out at various hearings, I guess there's an unease of this applicant and certain owners of moorings, because there have been, several others before this applicant and some coming. There's an unease about, well, what might the situation be when a new plan comes in, and they're entitled to apply for a resource consent for preferential occupation. So I think that's the number of it. Mr. Cameron can.
No, that's fine, thank you.
So paragraph 61, I won't read that out. That's just summarising what was in the submission. Paragraph 62, in terms of the evidence provided on behalf of TAMI, it states there will be significant cultural effects. As Mr. McSorley notes, well, actually it's in his summary, so you'll yet to hear from him about this, but he notes this in his summary. It's for iwi to determine if there is an adverse cultural effect from the proposed activity. is for you to decide from the matters that are relevant to consider whether there is sufficient evidence of those effects on those values. And I comment on this below. So paragraph 63, some of the matters raised by Tammy are more appropriately dealt with by way of plan review. And this is under the headings of tēnā rangatiratanga and kaitiakitanga and their evidence. And that's, for example, that the plan is outdated and lacks a robust spatial planning framework. That's not something for you, in my submission, to consider as part of this application. Paragraph 64, kaitiakitanga, in relation to the placement of moorings, as mentioned in the evidence of Tammy, again, this is not something you can consider. The moorings are existing, excuse me, and permitted by the Regional Coastal Plan, and any effects of those, in my submission, can be covered by the permitted baseline. Paragraph 65, the assertion that preferential occupation reduces the ability to offer safe haven to all vessels is, in my submission, factually incorrect in this situation, given the amount of time the MV is not operating in the southern fjords at all, or when it is, there will still be at least 2 moorings available and plenty of space for other vessels to anchor, as I've said. Paragraph 66, Modi, there is no evidence of overcrowding, increased human activity or displacement from safe anchorages, nor will access be restricted or altered. The only changes I've said from what currently occurs is the applicant is seeking to formalise what happens by way of consent. Paragraph 67, manaakitanga, as again set out in the evidence of Mr. Cameron, the applicant is providing a safe haven for vessels by allowing the free, unrestricted use of the 3 moorings when not in use by the applicant, which I keep mentioning is for a considerable period of the year. And as I've also mentioned, the applicant has also said, importantly, it would not require a vessel to leave a mooring in adverse weather conditions. Paragraph 68, why? The applicant cannot own or control the water and is not seeking exclusive occupation rights, nor is it seeking to restrict access at all. There is a clear legal distinction, as I've said, between the 2 concepts of exclusive and preferential use, and the practical reality is, as described above, the 3 moorings will be available for vessels to use for a large portion of the year. Even if the applicant is on a mooring, as I've said, there's plenty of room for others to anchor. Moving on to the Harbour Master, or it should be Harbour Masters. Paragraph 68, as you're aware, Commission, there were 2 different opinions provided by 2 different Harbour Masters in relation to the same application. The original comments from the original Harbour Master, well, actually I think he was the Deputy Harbour Master, on the 19th of November 2024 were that he did not think the activities proposed would have adverse effects on navigational safety. Then after submissions were received, further advice was sought from the Harbour Master, Chief Harbour Master, who agreed with submitters that there's a scarcity of safe havens in the Fiordland marine area, and that preferential use of a mooring restricted to the applicant's vessel only could create a situation of vessel congestion, reduced manoeuvring space, and potential for collision or grounding during adverse weather events where other vessels are seeking shelter, particularly overnight, and this could lead to unsafe vessel relocation during extreme Fiordland weather. The Harbour Master then requested certain information, the pictures of the mooring setup and the mooring specification. And just, sorry, as an aside, Commissioner, you've probably picked up in the evidence of Mr. Cameron that given the regular vessel maintenance inspections, they don't have that information at the moment, but next year they need to go underwater to get the information that the Harbour Master requested, and that's quite expensive. And so there's an underwater inspection due next year, and so I think the timing of that would work with the condition that's proposed that that information be provided by, I think it's June next year. So just wanted to, it's just not that easy to provide the information that was requested. In paragraph 72, it's unclear what evidence the Chief Harbour Master had to make the assertions above in paragraph 70, particularly regarding a scarcity of safe havens in relation to the 3 moorings, the subject of this application, the possible vessel congestion and the manoeuvring difficulties. Paragraph 73, again, Mr. Cameron has given evidence about the relative scarcity of other vessels, and he's going to talk you through the actual room in each of these areas when he shows the images on the screen. Paragraph 74, Mr. Hodgson also notes in his Section 42A report, the problems identified by the Harbour Master can also occur under the current scenario, no matter who has preferential occupation or not of any mooring. But at the end of the day, as Mr. Hodgson noted, a skipper is responsible for the safety of their vessel and should always have a plan B.
One of the things I'm just interested, sort of grappling with a little bit with this is there's the moorings themselves are permitted activity and they've been established, so they're there lawfully. From in terms of matters for me to consider, what relevance is it about how well they're maintained?
Well, that relates to the explanation in one of the policies, 11.7.7.9, which accompanies the rule, which talks about if there is going to, I think it's in my submission somewhere, but it talks about if there is going to be preferential exclusive occupation,
Right.
ensuring that doesn't affect the safety of. So I guess if there was, I mean, Mr. Cameron can talk about this, if, for example, there was a very small mooring area and the particular type of vessel that was going to, anchor up to the mooring needed 100 metres within that mooring because of the type of vessel it is. Each vessel, I understand, needs a different, I don't know if you call it a chain area, Mr. Cameron can explain. That might affect how many vessels could actually anchor in that area
I see.
when the applicant's on the mooring. But so I think that's where it comes in, because it did take me a wee minute to grapple with that too. But I think, as Mr. Cameron will say, there's plenty of room in these areas, no matter if they need 150 metres of chain, which they don't, but that's where I think it comes in.
Yeah, okay, thank you.
So, the law, paragraph 75, I don't think I need to read that. Paragraph 76, I just set out rule 11.7.7.9. And let's see, paragraph 76.
Thank you.
And so paragraph 77, there's a suggestion that rule 9.1.1 might apply. This is in Mr. Hodgson's section 42A report, instead of 11.7.7.9. And although I think the coastal plan could be clearer, on balance, and I'm happy to talk through the detail of this, I think that section 11 of the coastal plan, as that specifically provides for structures in the coastal marine area, versus the more general section 9, which is about occupation generally for all types of activities. My view is that section 11 applies, and that rule 11.7.7.9 is the relevant rule to consider. And I think, look, I haven't put all of the objectives and policies in here. I think it doesn't make too much difference at the end of the day, but there's probably just one policy in section 9 that has a slightly different flavour to it in terms of providing for public recreation, I think, or ensuring that there's public recreate. Mr. Hodgson can help me out. That's probably the only difference between the two, but I think it is important to decide, well, is it section 11, which relates specifically to structures, and I think it is. And I think when you read the explanations to the rules, that helps with that decision-making process. If you just read the rules themselves, rule 11.7.7.9 does talk about establishment of moorings. Yeah, and so that's obviously not the case here, but if you read the explanation, that's, definitely refers to exclusive and preferential occupation.
And their occupation.
Yeah.
Oh, well, I can ask the planners about that.
Yeah.
Thank you.
Okay. So Section 104, paragraph 78, that's covered in the Section 42A report and the evidence of Mr. McTorley. So I only raise matters below where there is some disagreement or further detail is required or for emphasis. So in terms of the existing environment, paragraph 79, in order to assess the effects on the environment, you need to determine what is lawfully occurring and thus considered part of that environment. And as you've heard, the applicant has got an existing consent to carry out commercial surface water activities where the moorings are located and other areas. And while that consent is current, that activity, including the travelling to and from the moorings, is part of the existing environment and the mooring itself, which have already been assessed when that consent was granted. And I think a couple of the submitters raised the issue of increasing levels of activity, and in my submission, that's not relevant. Well, actually, it's part of the permitted baseline because they have a consent to carry out that activity. So, for example, any effects on, well, I'll talk about that in a minute, actually. The permitted baseline, that's been set out in the evidence of Mr. McSorley and in Mr. Hodgson's report. That's paragraph 81 and 82. Moving on to paragraph 83, that is just a repeat in essence of above.
So in terms of permitted baseline, the law says I may disregard.
It does say that, yes, that's right.
What would be a situation where I may choose not to do that?
A situation where you might choose not to do that would be, and I use this example later, the actual commercial surface water activities themselves. So if, for example, this was also an application for a commercial surface water activity and it was in Doubtful Sound where, there's a lot of, there's high landscape and natural character values, there's the presence of marine mammals, the bottlenose dolphins, and that, in my recollection, is that's a non-complying activity if the numbers are above what's set out in the plan. So if there was a combination of preferential occupation of a mooring, seeking a commercial surface water activity, which is non-complying, they would be bundled together to overall be non-complying. And in that situation, you might think carefully about the preferential use of the mooring and think, is it appropriate in this instance that I disregard any, authorised activities, given this is a non-complying activity? Whereas in this situation, I don't believe that any of those things are present. There's nothing that I can think of that would weigh against you exercising that discretion. I'm happy in my closing submissions to address that in more detail if you want.
Interested in your view?
Okay.
Yeah.
Paragraph 84, the changing status of use of the mooring. Changing the status of the mooring to preferential occupation will not lead to a reduction in publicly available moorings as asserted in the Section 42A report. It's only about, in my submission, a single instance of possible displacement when the applicant might want to use one of its moorings, and this is exactly what is already occurring in practice. The public availability of the moorings will remain exactly the same as it has been for the period the applicant has been operating under its current commercial surface water activity consent. I was just waiting to see if you had questions. Okay, so paragraph 85. There aren't any more vessels in the mix. It will just be that the applicant could now, if you grant consent, legally require another vessel to vacate a mooring if it chose to do so. It does that now via sort of communication and what I understand is a gentleman's agreement, but Mr. Cameron can talk to you more about that. Paragraph 86. If consent is granted for preferential occupation, the only difference between what is happening now and what will happen post the grant of consent granted will be the existence of the consent itself, given there's no increase in surface water activity. There is no increase in the use of any mooring. There is no change in what currently happens if the applicant comes across another vessel using one of its moorings. Paragraph 87. Given the above, there aren't any additional or new adverse effects on wildlife, habitats and ecosystems, landscape, amenity and natural character to consider. Preferential occupation in the current situation cannot have any adverse effects on these values. Paragraph 88, cumulative effects. Given the above, in my submission, there are no cumulative effects relevant to consider. Mr. Hodgson notes a cumulative effect of the proposal could arise as a result of a slight reduction in publicly available moorings, causing pressure on existing publicly available moorings and anchorage areas. I don't see how this is possible, though, given there isn't any increase or change in the activities of the applicant. It will carry on exactly as it has done for the past decade. In terms of the New Zealand Coastal Policy Statement, Mr. Hodgson notes Policy 3, which is about the precautionary approach. Paragraph 90, in relation to the precautionary approach, it's not relevant for you to consider in this case. The precautionary approach may be appropriate where there is scientific uncertainty or ignorance about the nature or scope of environmental harm, such as doubt about how effects arise, what creates them, and what might cause them. It's important to distinguish between cases involving true scientific uncertainty and those where the effects are known but experts disagree on their scale. And I've just noted the CETO case there. Paragraph 92, in the, CETO case, the court noted that a precautionary approach should only be applied where there is scientific uncertainty or ignorance about the nature or scope of environmental harm. Where the difference is mainly one of interpretation of the evidence, in that case on the extent of a sand system, rather than about how effects might arise, the court found it would not be warranted to infer scientific uncertainty and apply a precautionary approach. In my submission, there isn't anything uncertain or any lack of knowledge about the effects of the preferential occupation in this case, and therefore Policy 3 is not relevant.
Can you just confirm, is the case C2 or CETO?
I do believe it's CETO. Okay. I see I haven't given you the full reference there, so I'll provide that.
Well,
no, I haven't. So I'll, when I send my submissions in, I won't change them, but I'll put in the, I'll crack the change in so that you can see I've made that change, just so you've got that full reference. So just moving on to conditions of consent, the term. So at paragraph 94, all three submitters seek the application either be declined or granted for not longer than 5 years. The applicant agrees with the recommendations in the Section 42A report for the term to expire as the same time as the term of the applicant's commercial surface water activity consent. Paragraph 96, the applicant disagrees it's appropriate to consider policy 16.2.15 referred to in the Section 42A report at Section 4.1.10. This policy relates to commercial surface water activities only and was the result of a plan change which became operative in October 2024. And this related only to commercial surface water activities. It doesn't relate to moorings at all. In my submission, there are completely different considerations at play for preferential occupation of an existing mooring in a permitted anchorage area versus the heavily regulated commercial surface water activities in Fiordland. There is no mention of moorings at all in policy 16.2.15, let alone preferential occupation of moorings. Paragraph 97, the term applied for and recommended in the Section 42A report is consistent with 6 consents that have been granted for preferential occupation of moorings over the last few years, with terms expiring up to 2038. And hopefully Mr. Hodgson can help you out there with those. I've listed some of those in a footnote, and he can confirm that for you. Paragraph 98, as noted in the Section 42A report, applicants are entitled to as much security of term as is consistent with sustainable management. Paragraph 99, applicants are also entitled to have a reasonable expectation of equivalent treatment and equivalent circumstances, i.e. be granted a longer term as granted to the above 6 similar consents, unless there is a good reason to depart from the principle. In my submission, there's no such good reason here to treat the term of consent for the applicant differently to the other 6 consents granted. And hopefully,
so those consents you've listed, are you aware of any other consents that have been granted for a shorter period?
No, I'm not, and but Mr. Hodgson can hopefully help you out, the Commissioner. And the other thing I was going to say that hopefully Mr. Hodgson, I'm so sorry, can help you out with is in relation to the number of moorings that those consents sought. My understanding is, subject to your confirmation, that the majority of those, apart from the last one, which was Fiordland Charters Limited, were for one mooring. And so in my submission, if you're thinking about like cases being treated like, whilst also having regard to each case on its own merits, in my submission, this situation is quite different to all the others, even the Fiordland Charters one, because in the Fiordland Charters case, there was usage of the vessel by the owners of the vessel in addition to the actual commercial surface water activity. But in this case, you've got the applicant is operating the vessel almost all year round, apart from when it's undergoing maintenance, as part of its various commercial surface water activities it undertakes. And it is explicitly set out, so there's 3 moorings, and more so than Fiordland Charters, it's available, for at least 7 months of the year, if not more. So in my submission, there's quite different factors at play in this case, which almost sort of set it apart from the others, and there's even more public access available than in those other cases.
Thank you.
Paragraph 100. So in some cases, shorter terms than applied for might be granted because of, for example, potential for adverse impacts to increase or change during the term of the consent, or because of an expectation that new information regarding mitigation of adverse effects would become available during the term. Paragraph 101, a good example of this is commercial surface water activities in Fiordland. The increasing pressure these activities were placing on Fiordland was raised with Environment Southland by their partners, and as a result, the Council commissioned a report into the impact that this increase was having on that area. The conclusion of the report showed that if unchecked, the continuous increase in commercial surface water activity could have a negative impact on the natural and wilderness values of Fiordland, and Plan Change 5 was the result, and I've included a link to that. So in the absence of circumstances of the kind described above, the courts have held it's not efficient in terms of Section 5 of the RMA to require applicants to submit a full application in a short time frame, for example, 5 years here, when there's nothing to suggest it requires re-evaluation from a Resource Management Act perspective at the end of 5 years. And I'd also note the cost, I'm sure Mr. Cameron will reiterate the cost of pursuing these applications when they're limited notified to a hearing is not insubstantial. So paragraph 103, there's no evidence or justification whatsoever for either in my submission declining the application or only granting the 5-year term proposed by the submitters, given the effects of the activity are well known, the level of effects will remain the same as at present, the nature of the activity isn't changing from what's currently happening, public access is not being affected or restricted. In fact, in my submission, it's being enhanced by the availability of the 3 well-maintained moorings paid for by the applicant, and there isn't any uncertainty about future effects. Paragraph 104, in the unlikely, and I'd say extremely unlikely, event that effects of the activity change, there are review conditions proposed which could be triggered, for example, to ensure conditions of consent are consistent with new national environmental standards, regulations, relevant plans, or policy statements.
So from a legal, and I'll ask the planners this, but from a legal perspective, do you think that a potential review of the regional plan is a reason to keep a term shorter than matching with the commercial consent?
No, not at all. Because, well, firstly, if we just take the current situation, so the Act provides quite explicitly for when it is relevant to consider a proposed plan. So the legislation specifically provides for consideration of a proposed plan in Section 104 and the Act.
Yeah, I appreciate there's no proposed plan, there's no draft plan, I understand that. But the fact that there has been an indication from the council that they are reviewing their plan and at some point will amend it and that these issues are matters they're planning to consider. I think that seems to be common ground at least.
Yeah.
I don't know the timing of that, partly because of the government's current position, but do you think that's a relevant matter to consider in terms of term?
In this case, I don't think it's a relevant matter to consider. And the reason why I don't think it's relevant to consider in this place is actually publicly, we've got no idea what is being proposed in terms of the policies or goals or strategic direction of the plan in terms of this issue. No idea publicly at all. And so I know that the Marine Guardians may have a bit of inside information in terms of, they're involved in those discussions, but from my client's perspective, he's got no idea what those changes might be, where it's at. There's no proposal on the ES website, in spite of the government's prohibition about, okay, well, we are going to sort of carry on with this, strategic direction setting, and we will, notify the public, or we'll seek public engagement, over the next 6 months or a year. There's just nothing concrete or certain known about what it is that's planned. And so for you to consider it, I'm just not quite sure what evidence there is that you could, sort of hang your hat on to say, well, it's quite clear to me, as the Commissioner, this is the direction that ES is intending to head in. It's in the public domain, the public are aware of it, it's reasonably certain. Even in that situation, I would say it's still not relevant to take it into account, because it's not known whether that will become part of any notified, coastal plan at some stage. It's too uncertain in my submission about what is the goal. And it would be unfair to my client, because then he's at a disadvantage. He doesn't know what's going to say. How does he, make a submission to you about this? It's difficult for the security of their business. They haven't had an opportunity.
I understand all that. That's fine. I just wanted to understand the legal position around potential review and whether that's a relevant factor in a term discussion, decision.
Yeah. So there have been certain cases, and I think I've quoted one in here. I'm happy to provide you more information in my closing submissions about the sorts of instances where you might consider that, and the sorts of situations where you might consider that. I was trying to give the example of the commercial surface water activity. Let's just say there hadn't been a plan change, and that was the situation here where my client was applying for a commercial surface water activity in Doubtful Sound. And, there's great uncertainty about the effects of vessels, commercial surface water activities on dolphins, for example. And, if there was this massive kind of gold rush before the plan was being notified, that might be a situation where you might
say, clear effect that.
Yeah.
Okay, no, that's helpful. Thank you.
Okay. In terms of part 2, I don't think I need to read that out. That's just whether it's relevant or not, and that's covered in the section 42A report. And in conclusion, at paragraph 109, the applicant is seeking preferential use of its 3 moorings that it maintains for its own use and for the use of the general public when not needed. Given the very limited time it operates in these areas where the moorings are, as I've said, for at least 7 months of the year, when it's not there, all 3 moorings are available for public use, and the remainder of the time, at the very least, 2 moorings are always available, and as Mr. Cameron will talk to, possibly 3, depending on where the vessel goes in those areas. And paragraph 110, as set out in the section 42A report, the application is consistent with the objectives and policies of the Coastal Plan, the RPS and the NZCPS, and the effects of preferential occupation are minor, and vessels in Fiordland will get the benefit of safe, well-maintained moorings to use that otherwise would not be the case. And in my submission, the activity will achieve the purpose of the Act, and my submission can be granted for the term recommended in the section 42A report.
Thank you. In terms of conditions, so we have a recommended set of conditions from Mr. Hodgson, and there's been no others proposed by the applicant. So am I to understand that your client's completely comfortable with the recommended conditions?
Yes, Mr. McSorrow confirmed that, but yes.
Okay, thank you. Right. We are, look, we're perfectly on time.
Just
look at that. Yep, I'm going to take a short break, I think. 15 minutes. We'll reconvene at 10:15.
Thank you.
Thank you.
You might not get the keys on Friday till 4 o'clock.
Okay, thank you, Commissioner. So the next witness for the applicant is Mr. Blake Cameron. So you've read his, oh, Luke, I'm so sorry. This looks early.
We do normally go the other way around, but
Just look at me. It's fine.
Well,
it's up to you.
well, I think it would make more sense for Mr.
Probably
Cameron
would.
to go first, if that's
Yes.
right. Yeah. So Mr. Cameron has submitted some images which he will talk to explain the spatial reality. But the other thing, as I mentioned at the start, Commissioner, that I think might help is, having received the other evidence from the submitters, is for Mr. Cameron to talk through the reality of a trip in the Southern Fiords where the 3 moorings are. So he can explain, you know, how often they might anchor or moor up at one of these places versus another place. So I'll let him do those 2 things. Firstly, explain to you the reality of the operations, and then secondly, talk to the photos that he submitted. So
Yeah.
talk through.
That'd be great. Thank
Good
you.
everyone, Blake Cameron, on behalf of Fiordland Discovery Limited. So just a little background, I skippered the boat, captained the vessel for like 3 or 4 years, and now I'm managing the company for the owner. And so I have a great understanding of the Fiordland environment in all the places. It was during the COVID time when we ran basically full-time multi-day trips down through Fiordland, and we weren't really operating in Milford Sound because it was shut down. And so for 2 years there, full-time, just running Stewart Island and Fiordland. So it gave me a really great understanding of the ins and outs of the area and how it operates with not just us, but other operators in the area, the fishing vessels. Everyone gets to know each other, and we all look out for each other on that front. So just a wee background about that. So what are we starting with? So currently we are running our vessel. It's a 24-metre vessel. We have 9 cabins, and so therefore up to 18 guests on our multi-day trips. And I'll just focus on that because the moorings in question are relevant to our multi-day aspect of the business. The other part of the business is that from November 1 through to April 30, we operate in Milford Sound solely. So doing overnight trips and massaging that business, where we have to turn up and use our wharf space and things like that. And it's so we have 1 vessel and 2 operations with that vessel effectively.
So why do you do that? What's the drivers between the 2 different parts of the business?
Well, there's international visitors that come, and they don't have 6 nights, 7 days to spend on a long trip through Fiordland.
Yeah.
They are wanting a quick look into the fjords, and Milford Sound operates that. Our vessel is set up for overnight stays and has couches in the saloon, booth seating we have plated meals. We are one of the only operators who can do that. So we have our own slice of the market for Milford Sound, which is overnight guests. Real NZ operate a vessel that they can do that with too, but on a much larger scale. We take 18 people, they take, I think 40, 50, I don't even know what they take, 70. Yeah, so it's a different market again with that. So we have our own sort of piece of the market there that we look to use.
And in the Fiordland is it always a 5, like what are the,
Yeah, so our classic trip that was created by the owners, Rob and Kate Swale, was basically a 6-night, 7-day trip, starting from Doubtful Sound and finishing in Preservation Inlet.
Right.
So we would come across Lake Manapori, go over the Walmart Pass on a bus, and end up in Deep Cove in Doubtful Sound, meet the vessel there, get on board, begin our trip. You might spend a night in Doubtful Sound, and then you would try and go down the coast, so weather dependent, sea state dependent. When you do that, morning, afternoon, whatever, pop around the coast, and then you end up in Breaksea Sound, which is where our beach harbour mooring is, just in behind the islands there. And then basically we would spend 2 or 3 nights in Dusky, Breaksea area, and then we would go out around the coast again down to Preservation Inlet. And then the customers would fly out in a helicopter back to Te Anau. The other customers fly in to the boat, and we reverse the tour.
Yeah.
So that's our main tour. It's a really great introduction to the southern fjords of Fiordland, and people just love looking at all the different aspects of the geography, topography, the wildlife, going for little walks. So we have concessions for walking. We've built this business over the last decade to sort of, offer the best experience we can to visitors who want to learn about Fiordland and the area. And we're one of the main boats now still operating this. During COVID times, Real NZ operated their vessel down through there because there was no Milford, but they've since minimised back. I think they had two week-long trips this year, whereas we had 20. So we're still owning that space of these multi-day trips down through Fiordland, and it's a big part of our business. In fact, it's our main goal every year is to sell the cabins on those tours. And what we need is some surety that we can have our own skippers turn up at a safe haven as well. As everyone talks about everyone else turning up, and we need these moorings for everyone else's use, but we need them also. So this is half the battle here. As I say, we've had them in there. The reason we put them in there is because we've got 18 people on a boat and a skipper that they know if it comes in, the weather's inclement, they can grab a mooring and they have a nice safe place to stay at night. They're not worried about their anchor dragging and 70 to 100 knot winds. We get extreme weather on the field. So that's part of the reason for doing this. And now, that's basically what we're up to with our tours. So. Do you have any other questions?
Let me just check your evidence. So I think your commercial consent allows for 35 nights. Is that right?
What else would do that?
We can come back to that one, or Sorrelly can deal with that. I guess the question I asked your council was around whether it would be appropriate to have a condition limiting the you're looking for preferential occupancy, and I'm just testing in my mind about whether it would be appropriate to provide some sort of limit on what that preferential looks like, so that it doesn't turn into sole complete occupancy.
At this stage,
what's your view on that?
Well, at this stage, we're operating minimum weeks throughout the year, 20 weeks.
Yeah. So
on any given week, we can only be in one place at one time.
So you've got 20 weeks times 6 nights. Is that what you say?
Except though, so we've got a 6-night trip.
Yeah.
But we only have moorings in certain locations. So if we happen to go, so for example, if we come down the coast from Doubtful Sound in the morning, 9 times out of 10 we will not go to Beach Harbour.
Oh, I see.
Because there's nothing for us to do there with the customers.
Right.
We will go right down to the bottom of Wet Jacket Arm, bypassing that mooring.
Yeah.
And anchoring for the night.
I see.
So we don't necessarily plan to use them. We just use them when the weather dictates we can use them, and it suits whatever's going on. There's no set itinerary with these tours.
Right.
You have to work around the weather.
Yeah.
You have to work around the sea state, and therefore there's a lot of flexibility required around. And sometimes you might get held in by the weather and have to stay 2 nights.
Yeah.
but occasionally we don't use them at all. So I was giving that reference to give an indication that we are 7 months of the year
Not there.
not even there.
Yeah.
And that's the summer months, by the way, which
Yeah.
is the time that if a visiting boatie is coming, they generally come in summer, February, March, April. If you're a yachty from Auckland, you're not going to come down in the middle of winter. They're too scared to do that. It's a reputation that precedes at Fiordland, and a lot of boaters don't even risk going down there because their boats aren't set up. They think they're not good enough, whatever the reason. So it's not getting overwhelmed by visiting boaties because they don't know where to go, they don't know how to anchor, they haven't got enough chain. Most boats in Auckland will carry 60 to 80 metres maximum of chain. Well, if you're anchoring in 40 metres of water and you want 3 times the depth, you need 120 metres. So then all of a sudden they're tucked wide in up on the side and they don't know where to go. So effectively a lot of people don't bother coming down unless they've got a boat that can handle the sea to get around there. They've got the navigational capability. You know, most of them are better seafarers. You're not going to get rookies coming around into Milford, into Fiordland.
And what would be, what's to stop you saying, oh, well, we'll ditch Milford and we'll just do a whole business year round?
Well, that's not to be shy about, because if
Yeah.
if there was a chance in the future, there might be a chance that we need to expand the business.
Yes.
Because the one boat's getting overwhelmed. There's a chance that if we can get all our ducks in a row in the future, we may have a second boat. And if that occurs, that boat probably stay in Milford.
Right.
And then the rest of the other boat will then probably double its time down. And
yeah.
So there is a chance. And half of the reason we need a bit of surety around this is that for 10 years, we've been using these moorings for a company with no complaints by anyone about the placement of the moorings. And they're free use by everybody else in the area, commercial operators, visiting boaties, of these moorings. And, you know, I guess with the upcoming plans or whatever's going on, I don't know, but we just want some surety. The company is set and it's here to stay. And we need to know that we can have a place for our customers and our skippers to have a safe night at anchor or at a mooring in these locations.
Yeah. So you've got some images.
Yes.
What would be helpful for me is if you can explain what they're showing, and in particular each mooring, and this might sound like a dumb question, but does each mooring, can that only take one vessel, or could you have more than one ever?
No, you have one vessel on.
Just one vessel for mooring. Okay. Cool. All right. So if you can run, are they?
Right, so what I've done is just a wee bit of background on this. We operate a New Zealand-based software on the boat called WASP, WAASP, and it is a recording software, so we can record the seafloor.
Yes.
And so all the grey areas you see are where the boat has been and we've recorded. So therefore it gives you the depth. We can get 2 and 3D images of under the water and what it looks like. And you can see everything in there. So basically this is a safety mechanism for our skippers that we say, if it's been recorded, it's safe to go there.
I see.
So anyone new turning up when we're training in them and all that sort of stuff, we just say, stay in the areas where it's been recorded. You'll never hit a rock, you'll never do anything. But the other benefit of this software is that we can add in marks, we can add lines and stuff like that and do measurements and all sorts of navigational stuff with it, okay? And we can also see the contours of the seafloor around us. Yeah, so yellow is land.
Feel free to jump up if you want to.
Yeah, it might be easier for you. So yellow is land, and it's basically a representation of a navigational chart.
Yep.
Grey is blue is the water area, but no information around it apart from your contour lines.
Yeah.
And yeah. So this is our mooring, the red dot. And this, we put these marks in, these have been there for years, but this is a known anchorage area, all this area here.
Okay.
There are other moorings down through this channel here.
Okay.
and they are owned by different operators, and everyone has moorings on there. And then obviously out to the open water here. So this is a sheltered bay. The coast is out this way. The entrance to beach, the entrance to the fjord. So the waves come into here, they hit this island, and you get a sheltered area on the backside of the island. That's why it's shallow, 24.5 metres there. Okay. 10.6 metres there.
Do you know how many other moorings there are?
Oh, and here,
Yeah.
I'm not entirely sure, but I would say 1, 2, 3, maybe 5.
Okay.
We're probably 6.
5
or 6. Yeah. Yeah. So, but different operators have put them in over the years because it's a known safe place.
Yeah.
So the other one, if you go to the next slide. So it's a bit of just a drawn out one, just so you can sort of see.
Yeah.
And then I added in on this one a length. So basically you could anchor anywhere from this contour line here, which is 10 metres deep, say. Most boats draw, our boat, 24 metres, draws 2.2 metres.
Okay.
So that's what's under the water.
Yeah.
Most boats, maybe there wouldn't be more than 3, for example. So 10 metres you can anchor here. And this here, I believe, mate, is there another one of this? You can see it's 0.3.
This one?
Oh no, if you go back then that's right. I was just seeing if there was a depth on there. But you can see that's 20 metre contour there. This here is about 35 metres. So you wouldn't really anchor much more than this depth here.
Okay.
You might go out over this side, there's shallower, but in the sea of this contour line here, it drops into a hole. So I just put that length there just to say, look, if you anchor between here and here, you're a third of a nautical mile. It's 330 metres of distance in this area. Our mooring is us here, 24 metre boat. That's all we take up.
Right.
Okay. This is the area for anyone else to anchor is all the way up to here. You get another 15 boats in there, and all around here, whatever. So there's a huge area there. There's no lacking of space. And if you go to the next slide, please. This is the width. So 300 metres wide between this contour line and the shoreline, which is deep right up to the edge.
Right.
So basically showing you the width of this area and all the anchoring opportunities around it for any visiting vessels, okay? So when people are saying that Breaksy's under pressure, it's really not under pressure for any.
And this is the one of any of them is the busiest.
This is what we
Is it
consider
your-
the busiest, because one of the reasons it's busy is because a lot of boats can launch into Doubtful Sound, which is one of the roads that comes into the fjords.
Yeah.
So there's only 2 roads into Fiordland. One is in Milford Sound and one is in Doubtful Sound. And with the advent of fizz boats that are now twin engine, they're 10 metres long, they've got huge fuel tanks, people are carrying on 3-wheel trailers, or farmers from Southland launch their boats, they come around and they can now come down the coast into Doubtful, and they'll often come and anchor here or stay. And other boats will come into this area. And outside of this area, if you go out into the channel, it's hundreds of metres deep. So there's only certain places you can come in where the depth allows you to connect to the ground for the night.
Yeah.
Okay, so maybe the next slide. Next one. Oh, yeah, 28 metres. So moving south from Breaksea Sound, this is Sportsman's Cove, which is our other mooring location. And it's a very unique place to have a mooring, and it's very unique anchorage. It is in the middle of Cooper Island. So Cooper Island is this island. And if you go to the next slide, you will see there is a small gap here, and then it opens into this little natural harbour. So if you do not know about this little gap here, you would drive past and not even see it. You wouldn't even know there's a place in here that's so the locals know about it. Often we see the Otago University boat might turn up in there for the little excursions they do into Fiordland with the university students. The dock boat comes into here, uses our mooring, by the way, if we're not there. And other vessels who know about it, commercial vessels mainly, will go in there. Most visiting vessels don't seem to know. And you've got to be brave enough to get through the gap or know what you're doing. The anchorage for this area is out the front here. which
Okay.
even then, to be honest, this is all reef area. You see all these areas, different heights, and there's massive contours. So, you know, this is a fjord carved out by ice. And this is all reef here. So if you wanted to go fishing in here, you'd go fishing. That's a reef habitat. So you don't really want to be anchoring over this reef habitat. So not many people ever anchor there, but I do see on their chart they can say it's an anchorage area, but I haven't really seen anyone anchoring.
And are there other moorings in the?
No, so if you maybe go to the next slide, please. Yep, so this is Sportsman's Cove. You can see we've driven around it, and it's deep right up until these sort of areas. We could go wider here, but there's no point. But that's 420 metres long.
Yep.
And this is our mooring over here. And 34 metres deep here, 30, gets a bit shallower at the end, 25. So basically, if we're on our mooring, we swing around in this little X spot here. That's our 24-metre boat. There's not many boats coming in that are bigger than us. If you're a smaller boat, you could anchor in front of us, where you generally would anchor sideways to back here. And then you can.
Sorry, there's no other moorings in there.
The whole time I've been operating, no, there's one fisherman's tow line mooring over here, but that's, I don't know. I think it's just, they often have a stern line to the shore,
Oh, I see.
and they come in.
Yeah.
But no, there's no other
Not
vessel
commercial
moorings in
type.
no.
Yeah.
And if we were to anchor here, just to let you know, we would anchor probably a little bit further away out in the middle here, and then we would swing all the way around here. And if the wind changed direction, we could end up facing this way. So now you've got this area like this that we were swinging around in, whereas on a mooring, we take up this little space here, and that's our full swing ring. So there is a benefit to moorings in the fact that you do not sail all around the place. On a catamaran like ours, you don't have much in the water when the wind blows, and we're 3 decks high, we're 10, 12, 15 metres high. When we go sideways, we get blown out sideways, the wind goes extreme, and then you go all the way back the other way to the extreme, and you do this all night. People don't know you're doing it, but you are, because you sit inside and it's all nice and calm, and they're like, oh, ever change. But the wind's blowing and you're swinging around. If the wind changes direction, you've now got 100 metres of chain laid out here in the middle, and that 100 metres can chain, if the wind's strong enough, can flip you right over and you end up way over here, and the 100 metres chains back this way. So
a much shorter swing circle with the
a huge amount, so a third of what you would have if you were anchored. So in actual fact, this is a really popular mooring for everyone who visits Sportsman's Cove, because A, it's large enough for a 90-ton vessel, and most vessels are less than that. And B, you've got a nice secure place to stay the night. And if anyone else comes in, there's plenty of anchorage room for them in this area. Okay, next one, please. That just gives the width of the area, so 230 metres wide, 400 plus metres in length. Okay. Next. So going down towards, this is Preservation Inlet. Preservation Inlet is over 93 square kilometres of water marine area, and our mooring is up here in Isthmus Sound at the top of this long sound here. And it's called Isthmus Sound because there's a tiny wee land bridge just here that almost broke through, but not quite, so it's like an isthmus. So basically, this is one of the safe anchorages in Preservation Inlet. The other one is down here. Well, it's a bit hard to see, but this one here. This is Revolver Bay. So if it's blowing anywhere from the south, Revolver Bay is your go-to, and there's no moorings in there, it's just anchor only. Up to 30, 40 metres deep, put your anchor out and stay the night there. Fit lots of boats in there, it's huge. And then the other one is go to here. The other anchorage is over here. There's another one just in here that small boats use, but we can anchor in there if we want, or at Cuddle Cove, which is just here, famous. So they're mainly the go-to anchorages. There's another one here at the bottom of Coal Island, if the conditions are nice, and there's a couple more over here at in these bays here. If there's not a roll coming in, you might stay here, easy enough. So there's plenty of options around. It's a lot shallower, it's not as deep as a fjord, it has a lot more sand, and it's maybe 30, 40 metres deep. Even out here, it doesn't go into 200, 300 metres deep. Only up in these places it's really deep.
Are there other moorings around that?
No, so this is the only mooring in this area that we know of, and the rest is just anchoring for everyone. So a lot of visiting boats. So any weather from the north, west, northeast, anything like that, easterly right around to northerly, we can come and stay in this place. So maybe next one, please. And if you look closely at Isthmus Sound, our mooring is just over here, sort of off centre a little bit. And basically, when we go and stay on the mooring, we normally update the location. Sometimes it moves a wee bit like that, the buoy can move. But basically, if you were to anchor out here and say 30 metres of water to there, you're talking 315 metres of length. And then if you go to the next one, this is our mooring. If you're looking closely at the bay, so you can see here at the bottom it's 35 metres deep here, so you wouldn't really anchor outside of that. And then all the way into the end here, 315 metres. Next one, please. And then 252 metres wide. So a large space in there for visiting boats to anchor. And I can tell you the whole time I've been skippering the boat, and the amount of times we went to this area and stayed, I have one boat ever come and stay the night with me there. And normally boats will see you up there, or we would see someone up there, and we just turn around and go somewhere else, unless the weather is really bad and we're like, oh, we need to go up there because of safety with the wind. So plenty of room for other visiting vessels, once again, to anchor in there, if that's our complete swing room and space we take up on the mooring. So hopefully that's helpful to give you an indication of the area without a site visit.
Yeah, thank you.
Because the site visit is obviously tricky, and
As much as it would
but
be
if
quite
you were to
fun.
go and do a site visit, you would do an aerial view, and you would also be looking at this little tiny dot on the water and this huge expanse of water.
Yeah.
You just wouldn't be able to see where the anchoring area begin and end.
Yeah, okay. And so you talked about this year you've had 20 trips.
Yes.
Do you know how many in those trips, how many times you've come across another vessel on your mooring and had to ask them to move?
Once.
Which mooring was that?
Well, okay. Oh, it's a mooring that doesn't relate to this.
So of the 3 moorings you've just talked me through,
Yes. No, none.
none. This year you haven't had to move.
No, because I normally get told by my skippers if there was someone on the mooring, because we have a program that they communicate with me, because we have Starlink on the boat, so they just WhatsApp and send a photo, and sometimes we ring them up and have a chat to them about what's going on. And I haven't had any indication from the skippers this year that they ever turned up and anyone was on a mooring.
So no one was there. And how do you know, would you know in advance that there's someone on the mooring? Is there
well, the commercial boats have a system called AIS on the vessels, so it's like a location instrument that you can use. So when you look at your chart plotter on the vessel, if they've had their AIS on, you can see where those vessels are, and it gets updated every so many minutes. So we can look ahead and see someone's in there.
Yeah.
And then if we know them, because normally those are the commercial operators.
Yeah.
Most, and a lot of visiting boaties actually have AIS now too, because it's a safety, it's a search and rescue tool.
Yeah. So sorry, just for so the AIS system, a lot of the boats have it. You can see from your system where other boats are.
So just on your standard chart plotter, which is like it's like your old paper chart on electronic. Yeah. Yeah, on that system, which every boat generally has. Yeah. Doesn't matter who you are. You have a pop-up that comes up with a little outline of the boat, and you can click on the boat and it will tell you the information that they've installed, the length of the boat, the call sign, or the name of the boat. So then you can use the radio as you get closer within the zone to call them up and have a chat to them prior to you even seeing each other. So there's a way there to potentially talk to them and say, hey, what are you guys doing? Yeah. And I think the thing to remember about all this is that everyone are professional skippers. We're not just making it, like the guys who run our boats are professionals. All the people on the other vessels are professional skippers. It's only if you get a visiting boatie, and most of the time they're experienced if they're down in Fiordland. They're not coming down there because they don't know what they're doing. So they are very good at talking, at understanding what's going on. And the idea of using a mooring and it belongs to someone is not new. You know, if you went back to Russell in the early days of navigating, seafaring in New Zealand, when all those people, and they started throwing moorings off, they always belong to someone. It's not a new concept. This has been around for hundreds of years, even in England or wherever around the world. You place a mooring in the water, you turn it up. If I went to the Bay of Islands tomorrow and picked up a mooring and the owner turned up, he's going to be like, mate, get off, that's my mooring. You'd be like, oh, sorry, got caught, and boom, you're gone. You know, so it's not a new concept. This is just actually, you know, trying to, you know, I think you can be a bit strong in overlooking the fact that this is a law of the sea in a way.
I think that my experiences with coastal stuff is mainly in Marlborough, and obviously in Marlborough Sounds there are a number of moorings and things, and their plans set up is different to Southlands in the sense that you need a resource consent to establish a mooring, which includes the occupancy at the time. So the difference here is in my read is that in this region, to establish a mooring is a permitted activity, so there's no consideration of occupation at that time. So that's what you're seeking now.
Well, exactly. Yeah. And if I go, I used to work for the Harbour Master's office in Northland, and we had a moorings officer who deals with hundreds of moorings, and they have a software that gives them the swing room, and then they tell you this is where you can put it, but you own it, it's your mooring, and you pay fees annually to retain it. But you pay for the servicing, and all the servicing is monitored and stuff. So yeah, you can. This is not a new concept in New Zealand to have this sort of setup.
Okay, thank you. The conditions of consent. Have you had a look at the recommendation from the council planner and the conditions that are set out?
I may have read that at some point. Are you referring to? Let me see the final.
So if I grant the consent, it'll be subject to a series of conditions, and the current recommendation is the recommendations from the council planner with a series of conditions, and your legal counsel has told me that you're comfortable with those conditions. I just want to make sure that you are familiar with them and you.
Oh, I did read them a while back. I just didn't read them last night.
No, that's okay. I'm not trying to catch you out.
No.
I'm genuinely wanting to be sure that you understand what you would be getting yourself into and are comfortable that you can comply with those. So maybe don't answer me now, but in your legal counsel's reply, it'd be good for you to confirm that you understand the conditions and you're comfortable that you can comply with those. There's no point me putting a condition on a consent for you to go, oh, this isn't enforceable, I don't know how to comply with it.
Sure.
So it's important to me that you, as the person who will be using and implementing this consent, are comfortable with the conditions.
I believe the conditions are mainly around regular servicing.
Yep.
Signage on the actual mooring buoy to indicate the size and of the vessel that's consented for.
And in terms of the actually, could you take him to someone might be able to help me out. I'm just looking for the conditions which deal with the situation of if you do come across another vessel on your mooring, what happens?
Yeah, so that's just the general.
Just sorry, which condition is that?
I'm sure there is one.
Look, it was.
Possibly condition 5 in terms of record keeping.
Oh, condition 4. Is that the one you're looking for?
Yeah, there is one there. If I can read it out, if that's all right. When the consent holder wants to use one of its moorings that is already in use, the
Yes.
consent holder will use its best endeavours to ensure it can accommodate the other vessel using that mooring.
Sorry, where? Oh, they were at the end of your report.
Yeah, right. Go right to the bottom
Oh,
of
hit the wrong
yeah.
one, the wrong.
Laura's just trying to find it too.
Yeah, it's a little bit confusing.
If we're using
Sorry,
the
which condition are you?
condition 4,
Thank you. Yes.
So
Have you got those conditions in front of you? Yeah, cool. So the exercise of the condition 2 is the exercise of this consent is in conjunction with your other coastal permit. So that's your commercial one. And then 3 is the public may use the moorings when not in use by you. And then 4, when you want to use it, and it's already in use, you will use your best endeavours to ensure it can accommodate the other vessel using that mooring.
So
Can you see how that would work in practice?
when we turn up to use our mooring on the few nights that we're in Fiordland,
Yeah,
if somebody else is on there,
yeah.
we're encouraged to keep them on there.
Well, I know I'm asking you. How do
Is
you?
that
No,
what-
I'm,
well, that's what it says.
well, I'm wanting to know what do you think you would do in practice if that happened?
Well, I think it would depend on who's on the mooring,
Okay.
because if it was the Pembroke Fiordland Charters, they're like really good friends of ours, they're professionals. They wouldn't even wait till we were in there. They would be gone by the time we got in there, because we'd be on the radio to them. And they'd be like, oh, you're going to stay here tonight? Oh, don't worry, we'll move. Boom, they're gone.
Right. Okay.
Other vessels, visiting vessels, which, by the way, I've hardly ever seen on our moorings ever, you would just come up and have a chat to them, really, and see how capable they are. It would be dependent on weather conditions. You know, if it's blowing 40 knots, you might not say, oh, don't worry, we'll just anchor up over there, because we can control our boat pretty well.
Yeah.
Even when we're anchoring into the wind and 40 knots, because we're twin engines and power and all the rest, a yacht always gets blown off. So they'll end up having a drama trying to anchor. So you just leave them on there. But like, the fact is, you know, we are professional mariners, and we're not going to force someone off the mooring if they're not capable. But we also would like to use our mooring, because we have 18 people plus staff, 22 people on the boat who need a nice safe anchorage as well.
Yeah. Yeah. Okay.
So
Understood.
yeah.
So
it's
the
tricky.
scenarios are either you would say, please can you move, and they go off and anchor somewhere.
Well, often we just come in and say, gee, this is our mooring.
Yeah.
And are you, yeah. But then we just often, like, if it's calm conditions, literally drive up next to them
And talk to
and have a chat out the window.
Yeah.
And then they're talking to us, we just have a chat out the window. It's all quite convenient, and it's no drama.
Yeah.
We're not going to be ever upset. But like, the reality is, if they could move, it'd be beneficial to us.
Yeah.
We're a big boat, and I'm thinking of out of lunch.
And so where would they move to in that situation?
We're just next door.
So they just anchor somewhere.
Like Sportsman's Cove's got all that area to
Yeah.
anchor this
So
drop
just
into the
anchor.
mud.
Okay.
Yeah, so
No,
it'd only
that
be,
was what I wanted to understand.
Yeah.
Thank you. Great, thank you. Is there anything else you wanted to
um,
tell me about?
I mean, maybe another brief explanation of how the moorings are used at times in Fiordland. I've
Just
got
remember, if you've already told me, I
No, I
don't need to hear
haven't.
it again.
no, this is an example of what's happening with our mooring in Breaksea Sound right now.
Yeah.
So we have there's a commercial consent for it's called the Uni 2, lives in Sunday Cove. It's owned by.
So that's not one of these.
No,
Okay. Yeah.
no, it has a mooring sort of consent basically. Anyway, it's a very old vessel. The Uni's very old vessel, and it's being replaced. The replacement vessel has now turned up in Fiordland, but they haven't removed the old vessel.
I see.
So the replacement vessel has been using our mooring in Breaksea Sound as a safe anchorage and safe haven for the last 2 months. So we haven't been able to use our mooring because there's a boat on it, but we're doing it because it's helpful to our friends and their consent while they're waiting for Environment Southland to decide what to do with the old boat and going through that process. So it's a really good use of a mooring that can withstand, you know, a big boat like the Uni 2. I mean, we're talking, I think it's 50 feet or bigger. I don't know. It's quite a big thing. I haven't seen it yet, but it's turned up. So like, these are sort of examples of having moorings are actually really useful for operators in Fiordland National Park. Like, if he was to leave that boat on anchor, he'd be worrying about it all the time. But having it on a mooring for 2 months, maybe even another 3 months. I don't know. This might be next year before we. But it's helpful. You see what I mean? Like just having the option to have that.
Can I ask you one more question? Are you able to bring up the comments that came through yesterday from the harbour master? And it's actually an email chain that was circulated last night or today. You got lunchtime yesterday. You got a copy of that? Have you got a copy of that?
When you've seen, but
Yeah.
I'll bring it up.
Someone got a hard copy? So what I'm interested in this document I'm just going to show you, there's a email back and forth between Lyndon Cleaver, who understands the harbour master, and Ryan Hodgson, and there's an email dated from Lyndon to Ryan 8th of October 2025, 10:29 a.m. About
So you said 11:20?
10:29. It's the email that sets out the comments in relation, particularly around the submitters' concerns and things. And there's in there he's got a saying that in his opinion he'd like you, the applicant, to supply some additional information. And there's pictures of the mooring setup and mooring specifications. Can you see that?
Yes.
Yeah. That information, is that information that you would normally, do you hold that information? How would you obtain it?
Well, normally you would have a operator that you hire to go in and place these moorings. These are 10-ton blocks.
Yeah.
They need a crane and everything to actually put them in. They're very heavy when they're out of the water. I don't know, how do I say this? In a more professional area of the world, you may have somebody who does that job.
Yeah.
And gives you a schematic of everything they've done with the chain sizes. But 10 years ago, when we had Ludger put them in, with his boat, you know what I mean?
That's fine. Yeah, so you
He
haven't got the
doesn't
information.
give you this information.
And so, excuse me. Thank you. So you don't have the information at the moment.
No.
And I think there's a recommended condition of consent that you would provide that information next to your review.
Prior to June 2026.
Yeah. And you're comfortable to do that?
Yeah, because it's actually coming up. It's perfect because it's coming up to our 3-yearly inspection time anyway. So we will lift them as best we can and replace any parts on them and keep them upgraded. The chain can wear out and stuff.
Okay. That's all I have for you. Thanks very much for answering my questions.
The only other thing can I mention, Commissioner, real briefly, is just about the navigational safety, because it has been a big topic. And navigational safety is a really, obviously keen part of our business as much as it is for everyone visiting the area. And I just feel like the moorings are really conducive to this. Like if you take away all these moorings, I mean, it'd be a different story if there was a plan for Environment Southland or Marine Guardians to say, well, to get rid of all these moorings, but we're going to go and put in all these moorings for people to use. But there isn't a plan for that because of the cost, I dare say. And so therefore, I really think that these moorings are crucial to the area, and losing them would be a really sad day for Fiordland National Park. And so that would just be my 2 cents worth on that.
Although to be fair, the application isn't to put in or remove it, for you to use it with preferred occupation. So if this was declined, presumably the mooring would still stay there. You'd just carry on and use it as you do now. Is that right? Or is there another outcome you see?
No, I thought there might be a chance that they would tell us to remove it. No? Am I wrong?
No, I don't have the ability to do
that. No, that's right then.
Not all powerful. No, I don't think any of the parties are suggesting your moorings aren't there lawfully. So your moorings are there. This application is to give you that preferred occupation.
Okay.
Yeah. So I just wanted to check that with you. Okay. No, that's fine. I understand your point around the moorings providing an efficient use in terms of space, though, rather than anchoring. think that was a useful point around navigational safety. Thank you. Okay, thank you.
Sorry.
Bring your evidence up. Just give me a moment. Oh, great, thank you. And you've given me a summary here. You just plan to read that?
Yes, thank you. Just taught that quickly, and I have noted.
We got this electronically.
I can send it to you.
Yeah, I don't need it at this moment, but if you could just send that through, thank you.
Yes, and I've noted those 4 points I think you've raised, so I can talk to those.
That would be very helpful.
Okay, thank you, Madam Commissioner. Key matters that I briefly want to summarise today are the environmental effects of the activity and the relevant statutory considerations. Firstly, to assist you, I'd just quickly like to respond to the evidence submitted by Te Ao Marama late last week on behalf of Auraka Aparima Runaka. At paragraph 52 of my evidence, I discuss cultural effects and the submission of Auraka Aparima Runaka. Having now read the evidence of Ms. Peterson, I do wish to provide further clarification. I acknowledge the important Waitahu cultural values associated with the Fiordland coastal marine area, as identified in her evidence, and do not dispute those. Ms. Peterson, at section 7 of her evidence, outlines what she considers other significant adverse effects of the proposal on cultural values of mana whenua. I acknowledge that only mana whenua can determine if there is an adverse cultural effect from the proposed activity. Relying on the evidence of Ms. Peterson, and as discussed in my evidence, I do, however, note that concerns with the operative regional coastal plan cannot be addressed by the applicant. The way the operative coastal plan defines preferential occupation as opposed to exclusive occupation is also clear and is outlined in my evidence. I've also provided an opinion that the permitted baseline of the coastal plan should be applied in this instance, and as such, any adverse effects associated with the 3 existing moorings can be disregarded, and that would include any adverse cultural effects. In reaching that conclusion, I do not dispute Ms. Peterson's opinion that the activity may have some adverse cultural effects. Ms. Peterson's evidence at 6.4 provides an explanation of the practice of manaakitanga. The applicant, in providing moorings for others to use, appears to be acting in a manner consistent with assisting others with safe passage and travel through the Fiordland coastal marine area. As outlined in my evidence at paragraphs 46 to 48, proposal will have positive effects on navigational safety for both the MV Dual and other private vessels that choose to use the moorings. The proposal will also have positive public access effects. As outlined in paragraph 16 of my evidence, Fiordland Discovery hold an existing coastal permit for surface water activity in the Fiordland coastal marine area, and this permit enables their business activities via the vessel MV Dual. The receiving environment includes this aspect of FDL's activities at the application sites, as this surface water activity is undertaken under an implemented resource consent. The applicant uses the moorings to navigate safely in the coastal marine area and to assist with its operations consented under that consent. Just in summary, in terms of environmental effects, they've been outlined and discussed in my evidence. And in my opinion, the proposal will have no significant adverse effects and will have positive environmental, social and economic effects. My opinion on effects aligns to that of the Section 42 report writer. I've discussed the relevant statutory framework in my evidence. In my opinion, the activity is consistent with the relevant objectives and policies. And again, that aligns to the conclusions of Mr. Hodgson's recommending report. In conclusion, I think the activity is consistent with the purpose of the Act. That's the summary.
Yeah.
Would you like me just to quickly talk to those?
Yeah, do that and I'll see where we land.
Okay, thank you. So I think the first point was just around, and Ms. Lenahan touched on it, the applicable rules.
Yes.
And I've, in my opinion, the correct rule is 11.7.7.1, which covers preferential occupation of moorings. That's
One,
identified.
was it point?
One is the mooring place, like the placement or having a mooring permitted activity. I think you mean 0.9.
9.
I may do, yes, yeah.
I've got it up. It's the rule 11.779 moorings for which preferential or exclusive use is required.
So it's the rule that's was included in the resource consent application.
Yes.
Obviously that consent application was accepted for processing under section 88. The other mooring consents that I've been involved with are also under that rule. Except maybe there's some, some of the language and some of the explanation, some of the rules or policies may not help. Ultimately, it doesn't change the activity status. That's where I've landed with that one. I think the second.
Sorry, you may come to this, but the point I think Council was making was that if the other rule, I think it's 9 something.
9.1.1.
Yeah, if that's the appropriate rule,
yeah,
there may be a different policy framework that applies, and I was interested in that, and I wanted your view on that.
Yeah, well,
whether, in fact, it actually makes a difference about which policies apply or not. Do you think it does?
Well, my read on Rule 9.1.1 is that it's covering other structures in the coastal marine area other than moorings.
Yes.
So, I'm pretty. My opinion is still that 11.7.7.9 is the correct rule. So.
And if I find that it's not that rule and it is 11.1.1.1,
yes.
do you think that there are different objectives and policies that are relevant, or do you still think the objectives under section 11, objectives and policies under section 11 are still the appropriate because they do relate to moorings?
Potentially there could be other policy provisions that are relevant. Just probably need to check with.
No, that's fine. Thank you.
I'll just move on to your second question. I think that was around the review of the coastal plan and whether that's a reason to shorten the term of the consent. I think that's something that's been hard because there's a lot of speculation around what the new coastal plan may regulate and what it may not regulate, and it's. I think Ms. Lenahan's covered it. We haven't seen anything, and we can only proceed on the basis of what's operative. I think it makes sense to align the consent term to the surface water activity consent term. That means all the related consents will come up for replacement at the same time. That's generally how you approach those things when I think of other consenting processes under the RMA. It enables all parties to consider those related activities at one time.
So that effectively sort of be it's not bundling under in terms of its activity status, but the effects would all be able to be considered together.
Yeah. And like the obvious examples, perhaps dairy permits under a different type of coastal plan, but generally you have your discharge permit, your water permit aligned because they all relate to ultimately the same activity. So I think the answer is, in my opinion, the aligning to the expiry date of the surface water permit is appropriate.
Yeah.
And I think the third point you raised was around the conditions of consent.
Yes.
I think, the only comment I've got on those, I just wondered about the accidental discovery condition. It seems unlikely that there would be an accidental discovery, but I can't see any harm in it staying.
Yeah, I did have a question noted on that. I was going to ask Ms. Peterson if she does decide to attend around that, because and I was interested because there's no activity that's happening, there's no work, so I'm not sure. I was interested in when would a accidental discovery occur, but I suppose in the end, does it matter if it's there? Because if it's not it's not the end of the world if it's there, presumably as a condition. But
and that's the sort of way
is that where you landed? Okay, no, thank you.
And I think the fourth thing you raised was just a question around the conditions of the surface water
While we're on the conditions, have you got those handy?
Yes.
Just got a few questions. And I have had a quick look at a couple of other, or one other consent that was recently issued, and they do look fairly aligned with that, which is useful to know. The only one I really wanted to ask about was condition 4, which we touched on with Mr. Cameron, and I'll ask the same question of Mr. Hodgson, but so it says when the consent holder wants to use one of its moorings that is already in use, the consent holder will use its best endeavours to ensure it can accommodate the other vessel using that mooring. Can you explain to me how you would see that applying? Like what does that actually mean in practice? How would that be enforced?
Yeah, it's probably unusual, the language best endeavours.
Yes, and I suppose I'm particularly interested in to ensure it can accommodate, and what does that mean? Like how would it accommodate it if it's saying you can't use our mooring or we would like you to move?
Yes, I'm just trying to recall if this was used on another consent, but
I think it is on the
Fiordland charges.
yes, is that the other one?
Yeah. I think
Then about a year ago.
yes.
Yeah, that was resolved through the Environment Court.
Well, Mr. Cameron could probably just clarify, but my understanding is sometimes you may raft up on a mooring.
No,
No, okay.
No.
no, not with a 24-metre boat. No, it's
Well, that may be relevant to Fiordland charters, maybe.
well, effectively, we're asking for preferential occupation, so we can use our moorings when we turn up. If someone else is on the mooring, this is basically saying you're trying to encourage them as best you can for them to stay on the mooring.
Yeah.
Whereas what we're saying is like, if somebody's on the mooring, we turn up, can you please move? Because we've got a boat full of people and a business to operate, and we'd like to use our mooring. Spend hundreds of thousands of dollars on.
So
I think, Madam Commissioner,
Back to you about that.
yeah, why don't you guys decide what your collective view is on that?
I think Mr. Cameron did speak to it a bit earlier in terms of helping. We're trying to guide.
I think
people
what
in
they're
terms
trying to say in this is that would you be accommodating to assist the vessel in doing something different or staying there if the weather conditions, if you had something in there about weather.
Yeah, perhaps it needs a little bit of clarity because
Yeah.
I think you're right. I think that is basically what it's getting at. But I'm a bit concerned about the
It's a bit vague.
transparency of what that actually means in practice. So I think that we're all aware of the issue, and I'll leave that with you and Mr. Hodgson to come back on that. Thank you. Actually, I don't think I did have any others on the conditions.
Madam Commissioner, just condition 10.
Yes.
Just sorry, pick it up late. Just wondered if I think it's requiring twice yearly inspections. Just wondered if once a year was more appropriate and in line with generally what happens.
What is the usual practice?
The usual practice is once a year we'll dive on the mooring and do a visual inspection for a diver. Obviously, divers are available in the area a lot easier than having an outside operator come in at great expense to try and just have a look at it. So that's kind of what we do.
So if it was twice a year, would
well,
that
twice a year
come
is
through?
just we're only there for a few. Yeah, like it's just not that easy to do twice a year, and it's probably a little overkill for like if you see the size of these moorings, like the ropes are like this and the chain. Yeah, everything's massive. It's not just falling apart in 6 months.
Yeah, so Mr. Cameron, this is why I said to you, have you read the conditions? Because it's really important that you know what you're committing to.
Yeah.
Okay, that's useful. Thank you.
Thank you.
Are there any others?
I think that was it.
Yeah. Okay, and did we have one more point? Was that, I think I interrupted you, didn't I? We've covered that. I had a couple of questions in terms of cumulative effects. And you may have addressed this in your evidence, so feel free to take me to that if you have. What I'm interested in is there appears to be a number of consents that have been granted for various commercial operators for these preferential occupation. Notwithstanding the evidence from Mr. Cameron that in this case it doesn't appear, other than in one site, there doesn't appear to be a lot around these moorings. But do you think there is a risk of cumulative effects if council just keeps issuing consents of this nature? Do you think that, and if so, what is the effect? What is the cumulative effect?
Yeah, well, I think, and I'll probably go back to some of the concerns that submitters are raising about the current coastal plan,
Yes.
which is quite enabling. You talked about that.
Mm.
I think one of the problems with it is, in terms of defined anchorages, they're not actually spatially defined. So when you look at how the coastal plan identifies an anchorage, which is then a permitted plan rule 4,
Yes.
there's no actual zone. So that doesn't help. But I think I'd accept that that's probably a gap that needs to be plugged.
But that's to establish the mooring.
Yes, but I think what
Yeah.
I'm getting at, that would then enable, possibly at some point, those anchorages do get to capacity.
Yeah, but that's not a matter before me, is it?
No,
Because-
but thinking of cumulative effects.
Yes. So what I'm interested in, because I can't control the number of moorings that are established because they're a permitted activity.
Yeah.
So what I'm interested in is what is, if there is a risk of cumulative effects from granting preferred occupation of moorings that are already there or are permitted to be there. Do you think that's an effect?
No, I don't think it is, because what the applicant's seeking is that preferential use.
Of an existing mooring?
Yeah.
Yeah.
The mooring exists, part of the existing environment. It's a permitted activity.
Yeah, and did you have anything else?
No, thank you.
No, thank you very much. Thanks for answering my questions. Excellent. Right, we will hear from the Fiordland and Guardians. Mr. Young, did you have someone else joining you? We got someone online. Okay, have we got Rebecca McLeod online? Can you hear me?
Kia ora, yes, I'm here. I'll just be mostly listening in. Thank you.
Kia ora, welcome. Thanks for joining. I'll just pull up the papers. It won't be a moment. Thank you. And who's going to lead that? Have we got Ms. McLeod or Mr. Young? Who's talking?
I'll read this out.
Thank you. So I've got some evidence from you that was pre-circulated. Have you got something else you're reading out now? Or
No, just what's circulated.
okay, so I've read that.
Yeah.
So I don't need you to read that out.
Right, that's cool.
So if you could just take me to some key points that you want to raise.
Yeah, I'll just be making a few notes.
Yep, that'd be great.
Just to clarify a few points. Yeah, so obviously well, our biggest concern was under the ES plan,
Yes.
it's permitted just to put moorings anywhere. So there's nothing to stop more people putting in more moorings into some of these quite small anchorages, which then becomes a health and safety problem or a congestion problem with people trying to anchor in amongst moorings. As you understand, what was pointed out before, like to anchor at 30 metres or more, you need more metres of chain, and a lot of the boats that come, visiting boats that come to Fiordland don't have serious anchoring gear to anchor in that deep. So it can be quite restrictive, even though they're quite a big, some of these anchorages are quite a big area, there's only quite restrictive as to where these smaller vessels can anchor. The local people that, the locals of Fiordland all have reasonably good anchoring gear and they know these places pretty well. So, but it's just the visiting boats. That's the problem. Yeah, so at the moment, some of the Guardians, myself and Mark Post, and some of the ex-Guardians and and local knowledge fishermen are working with the ES on the new plan, which has been delayed.
Yes.
So obviously when that is notified, and then that'll come out for consultation, so that, you know, I know you guys are frustrated in the fact there's no, you know, there's rumours and no information, but at the moment we are waiting on that to get to the next step. So that's, you know, you can't get in discussion with everybody before you have something to discuss, basically.
Do you accept though that this matter here, I've got to make a decision on the application that's in front of me, and that there's no, and the decision must, or the application is made under the current coastal plan? Do you accept that?
Yeah, because that's, well, and that's
what I have in front of me.
What
That's
everybody, you know, like, everybody's quite frustrated under the current ES plan.
Yeah.
And it's just taking forever to come up with a new one. The usage in Fiordland of vessels is going high, is going up and up. There's definitely a lot more people, there's a lot more pressure on Fiordland. Right. One thing is this, it's actually 20 charter boats in Fiordland, and there's can be 8 or 10 of them in that Delphus, in the Dusky Breaksea complex at one time, and many of them have moorings. One of the other ones was the preferential. We've agreed to some preferential moorings being put in Fiordland, because the guys leave their boats there and fly out, so they're pure salt and Fiordland charters both have moorings that they can only leave the boat on that particular mooring for insurance purposes if they leave the vessel. Because there's obviously a risk if the boat goes ashore or something, there'll be an environmental problem there. So the Guardian, we have in the past accepted a couple of those because for that particular reason, because these guys do trips where they don't leave the boat. But some of the other charter boats actually fly out when they haven't got any clients coming in. So they're left for a bit. Yeah, so our main reason is just that more moorings will cut down on a lot of these places. So it is sort of work in progress.
Yeah, understand. Thank you. And the evidence I've heard today is that this application won't impact the number of moorings in the Sounds. Do you agree with that?
No, because we know that there's a whole lot of people waiting to see what the decision is here. And it will either go put more moorings in, or be seeking the same preferential treatment. Yeah.
So I'd like to just tease that out a little bit. So if this was granted, if it's currently a permitted activity for people to establish moorings, why would granting this consent encourage them to put another mooring in, to put a mooring in? If it's already permitted, they don't need consent to do that.
Yeah, well, it just people just see it as protecting their space,
right?
Or having a safe anchorage place, you know. It's sort of a creator of looking at it to protect the fishers of Fiordland. As these more and more moorings get put in, the commercial industry will get pushed out. So they
But the plan permits moorings now.
That's the problem.
Yeah, understand that. Yeah. And so to allow the preferential occupation, you think would encourage others to establish moorings, and they would seek.
And it becomes a business asset as well.
Is it not a business asset now though, if they've already?
Not really. I think it just changes that if it becomes preferential, people, you know, it becomes more of a business asset. If you sold your business, you can sell it as, you know, 3 moorings or 4 moorings or whatever.
Yeah, but presumably you could do that now because they do own the infrastructure. I'm
Yeah,
probably
I
asking
think-
the wrong
I think
person.
maybe
that question.
once you've got that staff status,
I see, the preferential, yes. Okay, thank you. Can I ask you, oh, sorry, have you got other things you wanted to,
no, thank you.
that's the main stuff. I've got it, I just, yes, no, that's fine, thank you. Sorry, you're not the submitter, so it's really important that I just talk to the submitter. Thank you.
Could I, excuse me, could I just add to what Pete's just been saying there?
I've just got a couple of questions and then I'll come to you, Rebecca, thank you.
Oh, sure, okay.
You explaining it, or maybe it might be you, Rebecca, who's the person to answer this. But I just want to understand a little bit about the guardians and your role from a legal position. So it says in your evidence that you're recognised as an advisory board for the Fiordland Marine Area under the Fiordland Marine Management Act, 2005. Is there any link to that and the Resource Management Act and the consenting process, formal link? Or is it just, so yeah, can you explain that to me, or do you know the answer to that?
I'm happy to take that one if you want, Pete.
Yeah.
Thanks very much, Rebecca,
Yeah,
appreciate it.
sure. Okay, so the Fiordland Marine Guardians have direct lines to different ministers, including the Minister for the Environment. That's the minister that appoints us, and the Minister for the Environment obviously oversees the Resource Management Act. So we have an advisory role there. But through that legislation, Environment Southland have recognised the Fiordland Marine Guardians as an affected party, and we've had that status for, so far as I'm aware, the entire existence of the Fiordland Marine Guardians, which has been about, well, which came first, the Fiordland Marine Guardians or the Resource Management Act? Resource Management Act. So yeah, for 20 years now, the Guardians have been officially recognised as having affected party status for all applications for resource management in the Fiordland Marine area.
Okay, yeah. And why is that? On what basis?
On the fact that we have this official advisory capacity through that piece of legislation.
And when you advise the minister on what sort of things are you advising the minister about?
So we're able to provide advice to the minister on risks to the values of the Fiordland Marine area, and those risks can either be activities that are occurring inside the Fiordland Marine area or things that are happening outside the Fiordland Marine area that could have an adverse impact on activities in the Fiordland Marine area. So it covers a range of there's a range of sort of defined topics that we include our advice on. So we have a particular focus on compliance, and that compliance covers all sorts of things from all of the agencies that have roles in there. So we often provide advice through to Environment Southland on compliance in terms of resource consents. We also cover things like fisheries biosecurity, marine pollution, visitor pressure. It's a sort of holistic and wide-ranging suite.
Quite broad role, yeah. Oh, great, thank you. Great, thank you. And again, whoever wants to answer this, I asked Mr. McSorley before about a cumulative effect, and I think in your evidence you've noted that that's a concern for you. Can one of you able to explain? Sorry, Rebecca, I don't think your name was on the evidence, so I'm not sure what your background is, but you might like to tell me that, and just in terms of how much weight I can give that. Obviously, neither of you are planning experts, presumably, but I'm interested in your experience from a guardian's perspective about what a cumulative effect might look like about more and more preferential occupations being granted.
Yeah, it was just more and more moorings being put in, like Beach Harbour, for instance, there's 5 moorings in there now, and which drastically cuts down the anchoring area. I know there's a large area out.
So that was the bit further down that, yeah, thank you. So there's 5 as well as,
In the area that's not where that was shown, you know, not all small boats can anchor there. It's just quite deep, you know.
Yeah.
And then, but there's just more and more moorings going in. And this is where we need this, obviously, this coastal plan. One thing is that, one thing we have looked at, I can tell you, is that we are looking at a similar system to Melbourne Sounds, where every mooring will have to be registered, and it'll all have to have a warrant of fitness. It'll have to be lifted by an approved operator every second year. So there's, you know, there's some, you know.
and I know in Marlborough they have mooring management areas. I don't know if you're familiar with that, that identify areas and then they have a specific layout.
And that's one thing we are looking at under the new plan is some of the anchorages we've split in half. So you can have moorings on one side and anchoring on another. To try and just to get that spatial right. Because some of the moorings that have been put in the Fiordland have been put in right where people anchor.
Right.
And the moorings should have been put in outside the anchorage slightly. Still in a safe place, but they've taken out that whole anchorage with one mooring.
Yeah. And so, Rebecca, you mentioned you had some things you wanted to address me on.
Yes, so sorry, I should have started by introducing myself.
Sorry, it's my fault. I just sort of
no problems. So kia ora. I'm Rebecca McLeod. I'm a marine scientist and training originally an ecologist, so I don't know anything much about engineering and moorings, but I have been a Fiordland Marine Guardian for 12 or 13 years now, and I've been the chair of the Fiordland Marine Guardians for the past 10 years. I was the author of our evidence today, and I've basically worked with Mark Pache and Pete Young on bringing that evidence together. And unfortunately, Mark had another work commitment today, so he was unable to be here. I'm sorry. So I think there's a number of ways that the Fiordland Marine Guardians feed into resource consent matters in the Fiordland Marine area. We get involved quite often in individual applications because we have members of our group who are master mariners and have extensive local knowledge in the Fiordland Marine area. And I think in the past there have been times when the council has not had the in-house technical capability or local knowledge, and so they rely quite heavily on the expertise of the Guardians to provide advice about things like reviewing the engineering design of particular moorings that are proposed, for example, and the siting of those moorings. And we also bring in that sort of broader context, which is lacking from the council systems in terms of how that mooring fits in the spatial management of a particular anchorage. So we can, give it a kind of, I guess a broader context in terms of whether that the proposed mooring makes sense in that place and what the implications of it might be for other navigators. When it comes to these, this current, I guess, sort of trend that we're seeing with existing moorings being converted into consented moorings that have preferential or exclusive occupation rights, we're a little bit mystified as to what's driving this. It's many of the moorings, like the ones that we're talking about today, have been in situ for many years, and the operators have been working with that setup for many years without any issues that we're aware of in terms of being able to access those moorings. The only thing that's changed here really is that we've got this new coastal plan on the horizon, and the council has signalled that they are wanting to, there's some quite clear signals there that the new regime will be less permissive, more restrictive. So by operators gaining resource consent, those moorings will have become financial assets for those companies because they will be a limited resource, and so there will be a value associated with those moorings. So we, in terms of cumulative effects, this is always really tricky with these applications because we're only allowed to talk about the applications that are right in front of us, but we're aware of this broader environment where there are more operators wanting to, or looking to get preferential or exclusive occupation rights to their existing moorings, and therefore this does set a precedent. This case, we think so. I don't know. That's about all I really wanted to say, but we're quite concerned about how this is all moving in advance of the new coastal plan coming, because we really want to make sure that when the new coastal plan, which is desperately needed, comes out with a spatial management plan for moorings and anchorages, that there is still flexibility in there for the council to configure moorings to align with the new spatial plan, and issuing consents such as these will basically bake in the current mooring configuration, which we're not convinced is the best way to make use of that very limited spatial resource in Fiordland.
One of you might be able to answer this, and I suspect it might be you, Mr. Young. You're quite familiar with. Are you familiar with the 3 moorings?
Yeah.
Yeah, you've been there. How often would you have been there, say, in the last 5 years?
Oh, several times in each mooring. Yeah, I don't actually lay on those moorings myself. I prefer to drop my own anchor.
Yeah.
But yeah, I also skip with I'm a commercial fisherman in Fiordland, and I skip with that dock boat at times,
Okay.
southern winds, and also the charter boat for pure salt.
So you would have been to each of the 3 moorings several times, say, in the last 5 years?
Yeah.
Yeah, okay. And you obviously were here listening to Mr. Cameron talk about the amount of space and whether it's busy or not, and
Yeah.
certainly his evidence is that there is plenty of space in the area for boats if they did have to be asked to move from the mooring. Do you agree with that based on your experience with those areas?
Yeah, if they know what they, often they'll use the mooring because they haven't got good anchoring gear.
Yeah.
But there is space there.
There is space. Yeah. Okay. Thank you.
And
And
they've got local knowledge. Like it's all very well for some of us that have got all this 3D imaging and some pretty amazing stuff out there now. But a lot of these boats from Northland or wherever don't have good navigational gear.
And is that, I'm trying to work in my mind whether that matter is actually relevant, because presumably they're not going to be putting their own moorings in, one would assume.
No.
If someone's not going to be using the area very often, they presumably wouldn't invest in a mooring. So by providing preferential occupation to these moorings owned by this applicant, I'm not sure that I was trying to understand whether there is a link then to those issues that you've just raised around someone that might not have the appropriate gear.
Yeah, that's often why people use moorings. Like I on the dock boat, we go up with people. Well, I do anyway. Go and talk to people that yachts and that, and they may be on your moorings and they'll say the first thing they ask is, "Oh, is this your mooring? Do you want us to move?" Which is really a couple of times I've been told to bugger off. When that's there, they've found their little place of solitude and they don't want anyone else there. But yeah, not normally people are really good.
So your general, in general, so your general impression is that people understand that if they're on a mooring that they don't own, they respect that, and that if the owner came to ask them to move, they generally would. Is that your general? Yeah. Okay. All right, I had something there, it's just disappeared. I might have to come back to you. There was something that's just over there in my mind, quite linked it through. I think that's all. In terms of the conditions of consent, so you'll see Mr. Hodgins recommended a series of conditions. Have you had a chance to have a look at those?
No, but I just guess that
That's okay. If you haven't looked at them, that's fine. And Ms. McLeod, have you had a look at those conditions? No, okay, that's fine. Is there anything that, from a condition point of view, that would alleviate that if I did grant the consent and impose a condition, is there any type of conditions that you think would alleviate your concerns?
no.
No. So if I summarise,
Sorry, neither for me. We put conditions on the Fiordland Charter's moorings, but really our main concern is just this precedent effect that this sets for others coming and wanting to get preferential or exclusive occupation rights. So no conditions will really help that.
No, okay, thank you. That's very helpful. So can I summarise in this? I know you've said a lot of information, so it's not that I haven't listened to the rest of it, but as a general premise, am I right that it feels, from what I'm taking from what you said, your concern is more one of principle, that you would prefer that this applicant wasn't granted preferential rights because your preference is to have the coastal plan updated to better manage or more actively manage the location and type of moorings in the area. Is that right?
Yeah.
And
Well, at the moment, you can just put a mooring anywhere.
yes.
So council need to have a plan where before you put your mooring in, you have to apply for a place and you have good justification to put it in there.
But
be fair for every other boat.
Yes.
You know, as I explained before, some of the moorings have been put right in the prime anchoring place.
Okay, thank you. I understand that. But you accept that that's not something that I can decide on?
Yeah.
Yes. Okay, thank you.
You've been sort of stuck in limbo.
And in terms of consent term, I know none of the other submitters have said if it is granted, the preference would be for 5 years. So I can't recall if you guys have specifically said that or not. Is that your position, that you would prefer 5 years if it was granted, or is that not? Sorry.
Yeah, so that we can work through this coastal plan and then have it. And through that process, we should know. They'll know what they were going to accept then.
Yes. And I noticed there is a condition that has been recommended, which sets out the situation where a review of the consent could occur. And I'll just check the wording of that. And one of those times where this is the recommended condition, where a review of the consent could occur, it says ensuring the conditions of the consent are consistent with any national environmental standards, relevant plans or policy statements.
Yeah.
So my read of that, and the planners can correct me if I'm wrong, is that if the plan did change and it created a situation that was quite different to the current, that made this consent problematic for some reason, there would be an ability for council to review this consent.
Yeah.
Does that give you any comfort at all, or around that?
Yeah.
Some comfort?
Yeah, because we need to work alongside ES.
Yes.
To get that new plan up and running.
I'd be concerned that the council wasn't well enough resourced to make those changes as required, though, and to review any existing consents. So I think that's a barrier to flexibility if they're needing to review consents that are current. And there's also I think with Fiordland charters there was a clause in the conditions around the consent being reviewed if the business changed hands, or if and that they weren't transferable. They were saleable assets. But I'm a bit confused because I believe there's some overlap between the Fiordland Charters moorings and Fiordland Discovery's moorings. Some talk in that email that we appended to our submission around a change of ownership of one of the Fiordland Charters moorings. So I'm not sure if that's a particularly effective condition.
Well, the condition as it's recommended is talks about a review could be initiated on transfer of the consent. So if the consent is currently held by Fiordland Discovery Limited and they wanted to change that ownership of the consent, that's when that would be triggered based on that wording, including the commercial surface water consent that's already in place. Yeah.
Okay.
Okay, but I think am I hearing you correctly that Ms. McLeod, that you're a bit concerned that a review requires council to initiate and have the funding and resources to do that. So
yes, absolutely. I think there would be a barrier to the council.
yeah.
The more consents there are, the more expensive the operation will become.
Yeah. Okay. Thank you. And so a shorter term would alleviate that concern to some extent.
Yes, but acknowledging that we still don't have certainty on when this new coastal plan will be operative. It's a really tricky situation to be in.
Yes.
Yeah, one of the other issues with all the moorings in Fiordland is that wide range of moorings. Some of them are well maintained in like serious structures. Like there's no, they're put in by responsible people and well maintained. Some of the other ones are quite light and not maintained at all. So there's a health and safety risk with that. And that's why we need to have this plan up and running with a maintenance program in it, so that we know that for the safety of the people using them, that these moorings are safe.
Do you have any evidence around concerns about the moorings that we're dealing with here today?
No.
No. Okay, that's fine. Thank you. Is there anything else you wanted to let me know, either of you?
The other small thing is a biosecurity risk too with vessels on moorings. More moorings that go in because biosecurity check all the moorings every 2 or 3 times a year. If we end up with a lot more moorings, we're going to end up with a lot more checks. So it's really expensive. You're creating a structure in the water there. If there's any biofouling on visiting vessels, can attract to it.
Expensive for whom?
It's expensive for MPI to check them.
Commissioner, can I ask something?
No.
Sorry. I was just going to let you know about one rule for Fiordland.
All right, go one.
Before you come to Fiordland, you must have a clean vessel pass. So you have to prove that you've been out of the water, had your vessel cleaned, before you are allowed to go around into Fiordland.
Okay, that's fine. Thank you. I think we're possibly getting a little outside of, but that's very helpful. Thank you. Thank you very much.
No problem. I don't have anything further to add. And I'm sorry I have to go back to work, but thank you very much for hearing us today, Commissioner.
For your time. Appreciate you answering my questions. Thank you very much for coming and for answering my questions.
Yep.
Okay. Ms. Malloy, is it?
Yep.
Yes, great. Thank you.
I'll do the same thing. I prepared a big summary, but I think for the interest of efficiency and a lot of the points have already been well covered. I'll just summarise.
That would be very helpful. It's not a numbers game, so it's really just about me understanding the issues and making the best decision I can. So thank you.
So I think some of the things that we're looking at, so Create is an affected party, particularly with a focus around the commercial fleet that we represent. This role used to be covered by the Fiordland Fishermen's Association that folded probably a decade ago, and Create is an industry association that represents just over half of New Zealand's crayfish quota. So we're a significant economic contributor, a large fleet and an established fleet in Fiordland. And so we come with a focus around navigational safety and that link between commercial operators. when we're reviewing these applications, this is actually our first chance to review the details of these moorings. So when they're permitted, as an industry, we don't have an opportunity to provide feedback. It's the status of those moorings is permitted, not the individual mooring, as other people have discussed. So when we are reviewing the navigational safety, this is our first opportunity. And this application for us is disappointing that we haven't got the information that we need to make a proper assessment of our navigational safety. So when we put our submission in March, we requested further information around the weights of the blocks, the swing, the chain length, so that we can assess the impact of these moorings and on the anchorage spaces in these areas. Our fleet, like Pete when he's fishing, tends to anchor because we can't trust the safety of other people's moorings. So we do require anchorage in these all-weather anchorages, which there isn't many in Fiordland. So we're seeing increased use and sorry, like when storms hit, like the one that we had, I'm not sure if you're local to Southland, but you'll notice how many fewer trees.
Oh, certainly. Yeah, I live in Dunedin and it was pretty blustery there, but I understand it was much worse down here.
Yeah, and in Fiordland there was 160k winds. So in those times, it's essential that we have access to anchor in these key anchorages. To address some of the comments around the cumulative access concerns, Pete gave you a spoiler. We see the risk of these cumulative applications now that we're hearing that precedent has been set, that we're going to have no choice but to put in our own application for 93 moorings throughout Fiordland to protect the access of the commercial fleet, so that we have moorings that are of the right standard that our fleet can use them.
So are you saying you have 93 moorings?
No, we would have to install. So some of them the fleet have got, and some we would have to install in the areas that we would prefer to keep as an anchorage, like an open anchorage rather than a mooring. But because there's no consent avenue to protect an anchorage space, we're looking at having to do a really significant mooring application, because we can't risk more and more of these applications coming in and confined anchorages.
Yes, I'm just struggling a bit with this issue, with this connection that you're making. And I understand the context of the regional plan review.
Yeah.
But I am struggling to see whether by providing a preferential mooring occupation on someone's mooring that they own and maintain, how that then aren't your sorry, whatever they're called, the people you represent,
Fleet fishing.
the fleet fishing, isn't that on them to manage their own? I'm not quite understanding what they expect other organisers. Are they expecting to have moorings, to be able to use moorings that others have established?
Yes, and they also, or the primary is the anchorage, so this free unencumbered space within the recognised anchorages. And more people put more moorings into the recognised anchorages. And then applying for exclusive occupation. And so it's effectively creating an incentive now to put moorings in, consent them before the new coastal plan. And we're seeing more of these than we were. It's an increasing trend, and what we're also seeing is an increase is that people aren't applying for one mooring. Pete mentioned it earlier that like the Real Journeys one in Milford, they needed to put that one mooring in because it was a heavier duty mooring, so that they had safe storage of their vessel. It was an operational requirement, and it was one vessel, one mooring, which we see is quite different versus a boat that's only operating 140 days in this area, being able to get 3 and in some cases up to 5 moorings exclusively owned in these best high value anchorages.
Just to be clear, they're not, that they're already owned. They're seeking for preferential occupation.
Yes,
so the language is important, isn't it? That all the evidence I've heard is that they're not
I think,
So for the rest of the time when they're not using the mooring, it is available for the public, including your clients or?
yes, but moorings aren't all consistent. So you could put a mooring in that isn't safe for my fleet to use. And so that's where we have a challenge that not all boats can use all moorings.
Yes.
And so you're effectively owning a place that other people can't use because of the mooring design as well.
But isn't that, it's a permitted activity, so they're able to do that anyway. What I'm trying to understand is what the effect, and I understand the broader position.
Yeah.
I'm just trying to test so that I understand what is the effect of this consent being granted. That's what I'm trying to understand. I appreciate your broader position, and that's fine. But and I think I understand. I mean, what I've understood that you've said is that your industry relies on a free unencumbered space so that they can anchor.
Yeah.
You're concerned that by granting preferential occupation for existing moorings will encourage others to put in more moorings and seek preferential occupation of those, and therefore effectively reduce the anchorage space.
Yes.
Right. Okay. Yeah. That's helpful.
And our guys would need to be able to use moorings in weather events as well. And there's a risk to their well-being having to move off a mooring in a storm as it happens as well.
So do they have their own moorings usually, or
Some
do they rely on
tend to drop anchor and then use a stern line, so that stops them spinning.
Yeah.
So that's primary use. And so if someone was to go and say, for example, one of my fishermen has a place that he anchors and has a stern line and he's used that location fishing for 50 years. If someone was to then go and put a mooring there, he's not going to be able to fish the same locations that he always has. He's going to have to move his effort. He might have to, effectively exclude him from, his business to a certain extent. And that's why we're having to take this really seriously and look at it doing our own application, is because we need to have some surety that our fleet can continue to operate in these environments.
Okay. And the question for me though is whether the statutory framework as it is now actually how relevant is that to my decision? That's the thing that I'm trying to grapple with.
I think it's probably the navigational, like for what you can consider today.
Yes.
A lot of this conversation, you can't. The thing that I think for this specific application that you can consider, I don't think we've had appropriate information around the navigational safety, the drawings of the mooring, the weights, the swing radius of the boats that could use them to assess if boats can safely navigate around them.
So that you obviously heard the evidence of Mr. Cameron.
Yeah.
Was that not enough information to give you?
Yeah.
Why is that?
Well, we need to be able to see when you're going to drop anchor near it, the space underwater of where, to make sure that your anchor isn't going to get tangled up in their moorings, which is quite important, the swing radius, so that you can, if their boat or another boat, if they're open access, other people can use it. If it can spin like this, can you navigate around these areas? Can you have other fleet anchoring safely around them with that? So it's, in other applications, we get technical drawings, we have the weights, we have details of their servicing and history to be able to assess this navigational safety. And you'll see in the Harbour Master's correspondence that even he would have liked this information. I believe that, granted, it would have been good that when we asked for that information in March, that he'd asked for the applicants then, rather than waiting till October last minute.
But if the application hadn't been lodged, there'd be no way for you to seek that information.
Yes, but I also have no way of providing feedback until now either.
Yeah, I understand.
Do you know what I mean? So
yeah,
I don't have an avenue to say is this safe or not until now.
So in the conditions that have been recommended by Mr. Hodgkin, have you had a chance to look at those? Oh, brilliant. Thank you.
So The one around,
Yeah, why don't you pull them up?
so condition 5 around best endeavours, that was
Was it 4?
I've got it 4.3.2, section 5. On page 38 of.
It's condition 4.
It's condition 4, isn't
It's
it?
at the end of the.
So in the end of his, if you go right to the end of the section 42A report, oh, you might have notes on a different version, but there's a draft, I suppose, coastal permit under, is there attachment 4?
Oh, sorry, yeah.
If you go down to that, so we're all talking about the same thing.
Sorry, I was reading in the summary.
Yes, in the summary, no, fair enough. But in the actual recommended conditions,
Is that the right page numbers? Apologies.
no, it's right at the back. It's
Last thing.
What page is it?
Page 118.
very last attachment.
It jumps to and look, sorry, I was just finding,
Okay, you take time.
no, that's from. Sorry, the page numbers and the document are the same as the page numbers in the Adobe, so I jumped to.
Oh,
That's okay, I can
all right.
normally use a computer.
that's all right. It's all good.
Yeah, so the comments around the best endeavours.
Yeah, so condition 4 we're talking
Yeah,
about.
there's language that we came up with in discussion of another application.
I did about, so did that come out of the Environment Court appeal and then it was
No,
mediated?
so it was at a hearing, so we didn't end
Okay.
up going to, so this was the Fiordland Charters. And
Yeah.
the best endeavours, from my recollection, was that if a boat was moving using the mooring, that they would allow them to tie up alongside. So the Pete's on the mooring.
Yeah.
And Fiordland Charters comes along, Fiordland Charters hops on the mooring, and then Pete rafts up beside him for the night.
Right.
And so that was the application that was discussed around this best endeavours, which doesn't sound like it's suitable for this.
Yeah, to ensure it can accommodate. It was the
Yes,
sort
that's
of
what it meant.
accommodate that I was interested
Yeah,
in.
so
What does that
accommodating
mean?
this in that instance was raft up
I'd
alongside.
say.
So-
But it's not stated. Okay, no, that's useful background. Thank you.
So yeah, I think we would like more surety and clarity on how the safety of other users is, we don't use the word accommodated.
Yeah.
See on the-
So in that situation, are you talking about if there's someone on the mooring?
Yeah.
The Jewel, I think it's called, comes up, they're asked to move. It's in that situation, the safety of that vessel that's moving, having
Yes,
to
okay.
remove.
Yeah.
How do they deal with that situation
Well, I think-
safely? Is that what you're saying?
Yes.
Okay.
Having some practical language in there around that consent. would be
Yeah,
helpful.
Be a bit more direct. Yeah, that would be helpful.
I
Thank
think another condition that we would like is around these consents being non-tradable, because we do have concern that having these consents becomes, it is an asset for people's businesses. We've heard of these moorings being offered at between $250,000 and $300,000 in these key anchorages, like the ones that we see in Deep Cove are worth a huge amount of money, particularly when you've got a surface water consent, because it means you have exclusive occupation of these areas for, like if you sell this mooring to a company with a different surface water consent that's got a lot more days being able to park in certain areas, does have, Beach Harbour, where it is getting more popular and there's not going to be space for that many more moorings. It is a valuable asset, there's no question about it. So being able to not transfer these moorings means that people can't create a financial incentive or a financial asset out of a public good. That's one of our key concerns, is that, yes, I understand why people need access to the moorings that they're using for their operations, which, as we've seen, has worked very well to date. I'm not sure what's changed outside of trying to, I guess, gamify it a bit before the coastal plan. But if you weren't able to sell it, I think that's going to remove some of the and not with this application, but definitely with others that I've heard that there is a perverse incentive to apply for these because you can own and sell them. And so if there was a way of having a non-tradable.
Is there, the question though, is that justified? Is that, because I can only impose a condition if it's justified in terms of managing an effect.
Well, it's going to manage the effect that people are only going to apply for moorings that are essential to their operations, because there's not another incentive to make a commercial gain out of an application. And I think that's what we were trying to get to with the review of the review of the consent on a request to transfer it. But by having it non-transferable, then it doesn't create additional work for Environment Southland.
Yeah, okay, thank you.
Yes. Yeah, I think the solution presented about offering the details of the moorings for navigational safety after the consent has been granted before halfway through next year, for us, that doesn't suffice. I don't think we want to set a precedent that you can have a consent without offering that information. But understand that they should have had a bit more notice that they might need to provide that information. To the point around the inexperienced operators don't know where these moorings or these anchorages are, that's publicised in the Fiordland Guardian's book. And if you get a storm, the first thing you look for is a recognised all-weather anchorage, so that you know that that is a safe place to go in a storm. And those are listed in most maritime publications around Fiordland. If you didn't know what you were doing, the first place you're going to go are these recognised anchorages, which there are a few.
Sorry, and the point of, and why are you telling me that? What's the relevance of that?
That if a weather event was to happen, which often they aren't forecast, you see more vessels going into these safe anchorages. It's a different proposition for us than if you're applying for a mooring outside of these recognised all-weather anchorages. Like if you wanted to put them outside the edge of Fiordland on the open coast, go for it. But when you need safe anchorage for boats, this is when you're going to see it's not just one or two boats potentially showing up. It could be more as we have an increasing use of the Fiordland environment.
Okay.
Scan through my big document. I'm sure it must have been. Yeah, obviously we object to the exclusive and preferential occupational principle, but that I don't think is going to necessarily move the needle on this application. Yeah, I think just for us, I would have liked, and I think it's essential for these applications that we have really robust details about the moorings to assess navigation safety, especially when in the section 20 S24 report from the council, they say that if Cray8's happy, then we're happy with the navigational safety.
Thank you. Yep, cool. Have you talked to any of your members about these particular moorings?
Yeah.
And have they given you any information about whether there are any issues with them?
Beach Harbour's the one that jumps out the most. Sportsman's obviously really small, so.
Sorry, sticking at Beach Harbour.
Beach Harbour, yeah. So you've got.
What have they told you about that?
That.
Have you been there?
No,
No,
but I will hopefully be sneaking in February. I tend to go down about as far as Blythe from Milford when we're recce fishing, but I'm the email bandit of the Create organisation.
So your members, what have they told you about the beach harbour situation?
Yeah, that there is the 5 moorings that are there currently.
Can I just be clear? So the 5 moorings include this one?
Yeah.
Yeah, okay.
Yeah.
Thank you.
And so those moorings are in the best places to anchor,
Right.
and that they think there's only, because we've gone through the Fiordland coastline and the discussions that I've had with our members mapping where we have an operational requirement for moorings, where there's space for moorings for us to draft our own application. There's only, from what we can see, space for another 2 suitable moorings in Beach Harbour.
And have you got any evidence of that?
I've got the map drawings. I can get them sent across.
Well, I mean, if it's evidence, you need to back it up.
Yep.
So either it's just a comment, or if you want it to be considered as evidence, then
Okay.
by all means provide it. Yep. Okay, so your impression there's space for 2 more moorings, and then would there be room for anchorage around that?
I can get some more comments around that. Yeah.
So sorry, I told her off before, but I'm happy to hear your view on that.
Only in the deeper water, really, unless the moorings are put in the deeper water. So this is where we need this ES plan
Yeah.
to say you can put a mooring in, it's got to be way out there. And let these.
And have they? Sorry, no, I'll have to stop you now.
No, Pete's a crayfish man, so he can.
No, it's fine, but he's representing a different
Yeah.
submitter, so you can't jump in and
No,
have
sorry.
her go. Sorry, I've heard quite a lot useful information. In terms of have they expressed to you any situation where they couldn't, if they wanted to use one of the moorings, that they weren't able to, or any of those situations?
Right.
Well, I know you said they generally don't use the mooring.
Generally, they don't.
Yeah.
Okay. And again, it's because we don't know what those moorings are like as a permitted activity.
Isn't that a side issue though, that if you just communicated with the mooring holder, you'd find that information out? Like, why is that? I'm not sure that that's a consenting matter.
Well, I guess going through this consent, I haven't seen if this mooring's safe for, they've said that the mooring's safe for our fleet or for their boat, which is larger than most of our fleet,
Yeah.
but I haven't
Oh.
got,
Yeah, no, fair enough. Okay. And the other 2 areas, do you accept the evidence that they're not particularly busy, as far as you're aware?
they're not as important as the beach harbour.
I was just looking at busyness in terms of navigational safety and the risk of overcrowding or that sort of thing. Have you got any evidence on that?
Only commentary from the guys generally.
And have they raised any particular concerns?
Not with those ones.
Okay, thank you. Okay, I think that's all the questions I have. Is there anything else you wanted to raise?
I think that.
So you've obviously prepared a statement.
Yeah.
You haven't read it out or anything. Were you wanting to provide that to me, or it's just
No,
you've covered it?
It was just so I
Right,
had my
right.
notes to talk to the.
That's fine, no problem. All right, that's great, thank you. Excellent. So we are scheduled for a lunch break. Do we know whether Ms. Peterson is?
Anything that I'm trying to contact her.
No. I think we will break for lunch. And then if she wants to appear, she can, and then we'll hear from you, Mr. Hodgson. I understand the harbour master is not available, despite my minute yesterday, so I will consider whether I want to ask him some questions or not. If I do, I'll do that in writing. But I'll have a think about that over the lunch break. So I know we've scheduled for an hour. That seems quite a long time, but is there a reason? Is there an issue about getting food or something? Would you be comfortable with a bit shorter, just so that we don't spend all day?
As long as it's maybe one of the ES people can say, hello, I have to wait to get lunch across the road. It is quite a busy place.
Yeah, probably waiting 10 to 15 minutes. at this time of day.
45 minutes.
Yeah, well, shall we come back at 1 o'clock? Is that suitable? 1 o'clock? Okay, we'll
Yeah, just
adjourn.
what- yeah, just what it suits you.
Thank you. Thank you. So we'll adjourn now and we'll reconvene at 1 p.m. Thank you.
I'll text Kaz now and just
all back. No talking. Hey, hello.
So I've been advised that Ms. Peterson won't be attending. She did circulate some evidence, so I'll obviously consider that as well as the submission. At this stage, I don't think I have any questions for her, but I'll consider whether I would like to ask her some, and if so, I'll do that in writing. So Mr. Hodgson, we're up to your spot.
Yeah, cool. All right. Okay, hello everybody. My name is Ryan Hodgson. I'm employed by Environment Southland as a Senior Consent Officer. I've been asked to take over the processing of this consent application from a colleague once submissions were received. I'm the author of the Section 42A report prepared under the Resource Management Act. I have reviewed the evidence submitted by the applicant and submitters and have been present here at the hearing and taken notes of verbal evidence and questions. Okay, the key issues raised in the evidence hearing response, from what I can tell, largely pertain to the provisions of the Regional Coastal Plan, what it does and doesn't do and fails to do in some cases, the insufficient information provided by the applicant, justification for preferential occupation, cumulative and precedent effects, and consent duration, with just some other minor matters. So one by one, the Regional Coastal Plan. I acknowledge the concerns of the submitters regarding the limitations.
You're obviously reading from a statement there. Are you able to provide me a copy of that? Just so that it saves me taking
Yeah, I understand that. Yeah, I can do that.
Thank you.
I acknowledge the concerns of the submitters regarding the limitations of the coastal plan around mooring management and spatial arrangement in the Fiordland coastal marine area. However, effects of permitted activities such as the ongoing existence, placement and location of moorings with an anchorage under Rule 11771 may be disregarded under Section 104.2 of the RMA as our permitted activities. Similarly, the coastal plan does not seek to control the volume of vessels that can enter the coastal marine area. So people can put moorings as permitted activity in anchorages, and they can enter the coastal marine area. So these are two concepts that I want to make really clear. Preferential occupation rights is provided for in the coastal plan via consent, and there is no frame of reference to any future coastal plan and effects of any future plan in terms of, I guess, it could be a problem for our future planning in some way. There are other plans, for example, such as the proposed Southland Water and Land Plan that seeks to put limits on contaminant losses in future planning frameworks, such as Plan Change 1, 2, etc. The current coastal plan doesn't do that, so it's not forecasting for a future plan. Issues related to the adequacy of the regional coastal plan, I believe, are best addressed through a new regional coastal plan process. It's not something that can be considered during an individual consent application such as this. I acknowledge that there are broad concerns, but I don't think we can fix those broad concerns in this consent application. Yeah, so that's sort of, that's my sort of summation of those matters. In terms of insufficient information, so recent images provided by the applicant that you so well sort of showed before indicated to me that there is available space in those anchorages for anchoring or even installing new moorings as a permitted activity. I have detailed other moorings in my 42-hour report, but also that was discussed here today about how Beach Harbour has 5 moorings in that wee spot. I think that's well acknowledged, so that's fine. And in the other 2, as far as I could tell, there was at best 1 other mooring, but basically the whole anchorage is available. The applicant has offered to provide further information next year for June regarding, as a condition of consent, regarding the questions asked for by the Harbour Master. I believe that will ultimately address the concerns of the Harbour Master, because that information will be provided. I also acknowledge that there is a void in the interim between now and then as to, what is the mooring like. But from an effects point of view, what is the effect of that? It's the effect of between now and June, not knowing, I guess, what's underneath the water and how it works, and if that's a problem. I see that as a short-lived problem, and ultimate effects, given that they're existing, there is permitted activity. We have seen vessels on it, such as the applicant's vessel, being uninhibited or having no concerns with it. I think there's reasonable scope to suggest that maybe we're okay for now, and we'll get that further information by June next year, hence why I've offered that as a condition of consent, which should tick the box well enough, recognising that in an ideal world, this information will be provided as part of the application.
Can I just ask a question on that? So what would happen if the information's provided in June and it's the mooring isn't, there's a problem that would have been picked up if it had been provided earlier? Is there a risk of that?
Yeah, but I think that risk is unlikely, given that it's been used for some time by the applicant.
Yeah.
And there hasn't been any issues recorded to date. They tell us it can hold 90-tonne vessel. I'm not sure the weight of the applicant's vessel, but I assume it's less than 90 tonnes, and we know it's a large vessel. So I imagine, I don't know, I'm not an expert, but I imagine smaller vessels would result in dragging the mooring away or causing a problem or a hazard in that respect. So yeah, I just think the risk is likely low between now and June in terms of navigational safety aspects around the mooring structure.
Thank you.
A bit of a question around justification for preferential occupation. The Jewel is a large vessel with 18 to 22 passengers on board. They operate regularly in the area via an authorised commercial surface water activity. They own and maintain the mooring for the purpose of commercial surface water activity, which they expect to be able to use. I also recognise that that also provides a mooring for others to use at other times. And of course, the security of tenure. Justification isn't something that's defined in the coastal plan, but I think these are reasonably justifiable reasons to seek preferential occupation when meeting the justification policies. I recognise there'll be some disagreement about whether that's sufficient justification, noting Fiordland Marine Guardian's submission. But I think that's something that could always be disagreed upon, no matter who it is. But for me, they're enough to justify. Cumulative and precedent effects. I think the level of anticipated effects are uncertain. So we know, and as I mentioned earlier, that you can install moorings as permitted activity, and anybody can enter Fiordland. So there's so many moorings, and there's going to be vessels in the area. This is the existing state of play anyway, as a permitted activity. Does this change that? I mean, it's not a new mooring and it's not a new vessel. It's not adding to the existing volume that's there, and it will be used anyway, even without a consent. So it doesn't actually change anything. So proposal is not seeking to change the existing number of moorings or vessels. So it's unclear where the extra pressure will come from. apart from, I guess, anecdotal ideas that without evidence that there's increasing pressure. So for me, there's insufficient evidence to demonstrate how this proposal will reduce mooring availability in the coastal space for vessels. Mooring demand is the same. A vessel is displaced regardless of preferential occupation, either the applicant's vessel or another vessel. So the difference to me is small. It is in that rare occasion, as I understand it, that the applicant may come up to the mooring where another boat could be there, and then asking them to move. And that is the slight difference or the slight shift just in that moment when those few moments occur. So there is a slight shift, but it is minimal. And I would sort of just say that. So what is the impact of that? Well, I think it can be mitigated by conditions. And that is basically trying to, we talked about condition 4, trying to accommodate the other vessel and through best endeavour to accommodate them. Now, what does accommodate mean? It doesn't necessarily mean on that mooring. It could be accommodate in that anchorage, or it could be accommodate in a nearby anchorage. It could be through giving advice to these people from Auckland or Northland about what they can do in this very different environment to what they're used to. So it is about helping them. And I think best endeavours to help them through communications as described, I think are sufficient. And that way we can see the achievement of that condition. Is it enforceable? Well, I think if you can trace phone calls, emails, any form of communication that's taken place recorded, I think to a degree it's enforceable. You can check up on how you have accommodated others, how you have engaged or talked or discussed with them. And then that can be evidence to show, yes, we, through our best endeavours, we communicated with them, we told them where they can go, what they could do under the circumstances. And even in any case, it could still be on that mooring in a situation where it's late at night, raining, howling, and it might be the best in that moment where the applicant, as they have offered to themselves anchor and allow the existing vessel to be there, again, another potential solution in the toolbox. So I think there's enough there to cover off that sort of things.
So can I just be clear? At the start of this section, you talked about cumulative and precedent effects.
Yeah.
I think my understanding of what you've been talking about is really relates to cumulative effects and, well, actually, I'm not sure that really does. If you can assess cumulative separately to precedent, that would be quite helpful.
Okay, I'll note that down.
Yeah.
Okay, no, that's fine.
I mean, the points are relevant that you're making, but it's just in terms of in what context.
Separate that out, sure.
Yeah.
Okay. So you talked about communication. Okay, now in terms of more vessels and increasing pressure, that may happen. It may happen, yes. Even if there is an increase in vessels going through the Fiordland coastal marine area, the coastal plan enables the installation of new moorings as a permitted activity, which may help accommodate any increase in vessel traffic. And of course, as a permitted activity, this effect may be disregarded. So it's just worth noting that I know Create talked about installing 90 moorings. We mentioned earlier that moorings have a smaller swing radius by comparison to anchoring. I mean, it's arguable, but there's a case to be said that perhaps that's an opportunity to rationalise mooring space and freeing up room for others, and that's such a consent application, which I imagine will be a hot topic if such a consent application was to come about. I guess the other thing that I sort of want to really hit home on is all 3 moorings will be publicly available for 7 months of the year. I recognise the limitation in that promise being that, well, what if the activity changes and we get a second boat and that's no longer the case? That's really a subject for that consent application for the additional boat. You'll need a new consent to do that, and so that will be addressed there. But in terms of the existing environment that we're working with now, we have one coastal permit for a vessel, and we know it operates in these fjords for 5 months a year. And we know they can only occupy one mooring at a time. So for 140 days, that's, say, up to 50 days each. So one mooring would only be occupied for, approximately 50 days a year. Now, it was mentioned that from FMG and others, that other consented activities were allowed for preferential occupation. It was one mooring and one boat. Would that be more than 50 days a year under that circumstances? In which case, that would actually have a greater effect than this would, because in this case, it'll be less than that many days on this mooring. So I think there's something to be said for the minimal occupation that would actually occur under this consent application. Consent duration. So 5 years was discussed, and it's, this has been the position for a few years now, and I believe there have been some applications that, in order to avoid a hearing, just agreed to 5 years. And only recently have we ended up in hearings where that's been strongly challenged. Charters was one. Initially, that was granted for 5 years, but under appeal, it was extended to align with the commercial surface water activity. I think the reasons that the applicant explained before is, I concur with those in terms of aligning that activity. Again, we see farming activities and others where you align consents. It's the same sort of activity. They're intrinsically together and integrated. I think in terms of efficiency of management, it makes a lot of sense to align the expiry dates. I'll just read what I've got here, hang on. Okay, so the submitters wanted a maximum of 5 years based on an anticipated regional coastal plan review. There's also one there when a new plan will be in place. So we know there's a plan stop until 2027. Okay, so that's 2 years from now, more than 2 years. And then there's still the process of putting it all together and then notifying it. An operative plan could be far more than 5 years away. So even the notion that a 5-year term will be enough to get us through the plan change is probably overly optimistic in terms of when we can expect an operative plan to be in place. So I don't necessarily think a short 5-year term achieves the goal of having a sorted new coastal plan in time for that. So there's that slight problem as well.
And on that, I'm based in Otago, and certainly Otago Regional Council will be able to tell you about that situation, which has happened a number of times where they've issued short-term consents, thinking that they'll have a new plan, they don't.
Yeah.
And then you pull back here. So there is some real risk in that, I think, particularly in this political environment.
Yeah, so for these reasons, I think a 5-year term is unreasonable, and it just makes sense to align the activities together, noting that they're connected in terms of their effects, and interestingly also when they all expire and we go through, if they wish to, a reconsenting process, we can manage all the effects together, which I think is also more efficient in terms of, sorting it all out at once. There were minor matters that I only consider minor, such as which rule applies. We talked about Chapter 9 and Chapter 11, and which is better. And I agree that Chapter 11 is as a whole is really more like about this type of activity, which I agree with. And my point in identifying these two rules is that we have treated this activity under Rule 9.1.1 before many times.
Oh, okay.
So we've done both. And the difference, as I understand it, is that when we're installing a new mooring, we'll refer to 11.7.7.9, where it talks about the placement of a mooring before anything else, preferential or whatever. But at the end of the day, it doesn't matter because they're both discretionary activities, I think the policies under both chapters apply regardless. And I think in my 42-hour report, I've identified policies from both chapters. And in any case, I think we meet those policies. So it's just a quirk in the coastal plan that's not super clear. It would have been helpful if there was a non-placement of a mooring rule under Chapter 11, but there isn't. But that is what we have to work with. Okay, so after all of that, I remain of the opinion that subject to the imposition of appropriate consent conditions, the adverse effects will be no more than minor and are acceptable, and that the application is largely consistent with and not contrary to the statutory direction. As such, I'm of the opinion that consent should be granted. 15 years was initially sought, but since then, the applicant has agreed to turn the lines with their commercial surface water activity. I consider aligning these dates as appropriate to achieve administrative efficiency and desirability of a common expiry date. And that's it.
I have some questions on your report, but before we go to that, I want to just tease out the idea of precedent, and I didn't ask Mr. McSorley, and I might be cheeky and ask you a couple of questions in terms of precedent. And no doubt you might want to address this in your reply, but certainly it's my understanding from the case law that for a discretionary activity, precedent wouldn't normally expected to apply because the policy framework, the activity is sort of considered likely to be acceptable subject to the policy, consistency with policies and effects. So the word precedent sort of was flown about with some of the submitters, and I wonder if you can assess that now or whether we wait for the applicant's reply on that.
Yeah, look, it's hard to judge what precedent is being set other than, I guess, what's been described as, worry, I guess, and worry prior to a new plan. That's sort of outside the bounds of policy in the coastal plan. It's sort of like it's this external concern that triggers things. And even Fiordland Marine Guardians acknowledged that this sort of came out of nowhere to them. All of a sudden, people applying for moorings and things. So to a degree, is like, how do you even forecast that?
But do you think is there argument to say that, there's been previous applications granted? If the facts of the case are same or similar, then a commissioner is likely to come to the same outcome. Is that precedent, or is that just assessing the application on its merits?
I think you have to assess the application on its merits. That's the tools that you have to work with is does it meet policy, does it meet objectives? And nowhere in there is it forecasting for future limits or whatever that we're slowly building up towards. There's no hard numbers around that sort of thing. There's no framework for that. So we've mentioned a bit in this hearing that the coastal plan has limitations, and that's abundantly clear. But these are the tools we have to work with, and it's just a really difficult and awkward space in terms of effects, and this is why a new coastal plan, I suppose, is really being sought after now, because there's concerns in the community that say, we can have a proliferation of moorings, we can have all sorts of navigational safety concerns. We need a new coastal plan to address this because the current one doesn't.
And that to me is really around allocation of space. It's more of an allocation issue than anything else, isn't it?
Yeah, that's right. And without the hard numbers, we don't really know. But we've got we know how many moorings there are in an anchorage. We were able to identify that today, and we were able to know that there's ample space for anchoring still, whilst it might not be the best spot because maybe the mooring took up the best spot. There are still spots available. It's not as if they're short. spots. So for the time being, I think it's reasonable to say that for now, at least perhaps until the new coastal plan is operative, there is still space available. And I don't envisage that being all gobbled up in the next 5 to 10 years before a new coastal plan lands.
There's no evidence to
No.
suggest that, is there?
Yeah,
That's the point, really.
yeah.
Okay, that's helpful, thank you. Right, I'll just whiz through your report, some of the stuff you may have already answered. So have you got your report handy?
I do.
Thank you. So paragraph 3.3.6.
Sorry.
No, hurry.
336, was it?
336.
Yep.
Okay, so the first couple of sentences in that paragraph, you're saying applicant's coastal permit for the commercial surface water activity includes conditions limiting the number of commercial trips per year, 35 backcountry trips, which also limits mooring occupation. Then you say, in theory, this limitation could mean that the moorings would be available for use and occupation by other mariners for significant periods of time. I'm just interested in the in theory. What do you mean by that? Like, isn't it just a fact? I mean, I don't mean to be picky on you,
No, that's,
but I just want to
that's
understand
totally
what you
fine.
think.
Yeah, I think what I was trying to outline here is that because the application, from what I could tell before we could hear the evidence today from the applicant, is that it was for the whole year what we're applying for, and there's 3 moorings, and we're going to use 1 mooring. So I was thinking 365 days a year, 1 mooring will be used. So I had to sort of dial that extent down a little bit to what's currently authorised. And as we know, there's 35 backcountry trips, so there's only a certain number of trips that can be done, which that in itself limits the days that it could occur in. So there is some limitations more than maybe the full scope of what the application outlined. So I just try to narrow that scope down a little bit more.
Okay, no, that makes sense. And you might have, I think you've covered this, but that 338, second sentence, the submitters also suggested it would reduce the amount of publicly available moorings at suitable mooring sites, resulting in increased competition for these moorings, adversely affecting public access. Do you think there's merit in that view?
Look, it's minuscule. You could say that there's no merit at all because it's the same number of moorings, it's the same number of vessels. We're not, nothing's changing. But as I sort of mentioned earlier, there's that very subtle shift where you do encounter another boat, and if that happens, and I'm not saying it happens all the time, on the very few occasions that happens, there's a shift where you could shift them on, and it may be an inconvenience to them. Yeah, it's so minimal that I'd say it's no more than minor in terms of effect.
And in terms of Ms. Malloy's evidence, her concern was that it would sort of creates an incentive to put in more moorings and therefore reduce the anchorage space.
Yeah, so reduce anchorage space is, yeah, I see.
And the question then is, would that, if the moorings have preferential right, would that reduce public access?
I would say no, because the fishing fleet is existing. They're part of that area anyway. For now, right now, they have to anchor. So Craig mentioned that they're anchoring and not using moorings.
Yeah.
Arguably, it would save space in the anchorage if they put moorings in, because they would use up less swing radius. And so therefore, this existing fishing fleet could end up occupying less space than they do now. And under such an application, if they were to apply for 90 moorings, that's something that will be looked at very carefully, because there's a lot of moorings all of a sudden, and they're new moorings. And so you've got policy directing them to, directing us to think about rationalisation of space and space management. But then again, there's still the limitations of the coastal plan. I mean, in theory, they could install those moorings as permitted activities as well, in which case we have little control over where they're located. And then a few years later, going like, now we want preferential occupation of those moorings, which are now in odd locations, which is not ideal. So again, there's that side of, you could do it that way too, which would be unfortunate. But yeah.
No, I think that's fine. Thank you. So in terms of the harbour master's comments, I was mulling whether I do need to ask him any questions or not. And so at 3319, you've set out the info that the harbour master has asked for, and you've got theirs essentially in a condition and it'll be provided next year, and you've talked about the risk of not having it now. So we've sort of covered that. There was sort of also a general kind of comment in their comments around navigational safety risks. And I guess what I was going to ask is the navigational safety risk because of the potential that the mooring is not safe, or is there some other risk that they're concerned about? In your experience with these kinds of applications, is there another matter that, presumably the two risks are that the mooring is not safe and appropriate, or it's really busy. And
busy.
So is there anything, because we've heard evidence on both of those things, so I'm just wondering, is there anything else?
I guess to briefly summarise that, it's the idea that a swing radius here and then a swing radius here and do they bump into each other, and then the notion of if it's not well built, they could end up dragging the bottom of the mooring and then eventually bumping into something else or whatever, very simplistically. And so these requests sort of make sure that this mooring won't move and it can hold 90 tonnes, and the swing radius is reasonable in relation to other moorings, and as showed earlier, there's a good distance between moorings, so that's not expected to be a risk, but of course we need to make sure it's not going to be any drag. So they're sort of like engineering type concerns, and so that's the sort of thing that is routinely, and Craig were right to point out that this is fairly routine and is expected in that consent application, that you have diagrams and things like that showing this information, so we don't have to come to a hearing to discuss it, and then we can move forward.
Okay, no, that's I'm not sure if you can answer this, but it's a bit tricky because they're not here. So Te Ao Marama have sought the application be declined, and at 344 you've summarised that, and I've asked to be given the opportunity to develop conditions of consent. Are you aware whether, did you discuss any draft conditions with them? Or?
No, but I am aware they're involved in the appeal and the mediation for charters, and that these conditions largely align with those in very similar ways, recognising there's slight differences in the activity. And so, to a degree, I think that conversation has been had already, but
they haven't
said that under this application, of course. So I can't say that for certain, but maybe that's a discussion to have.
So there's Section 274 party for that.
Yeah.
Sorry, what's that application called? Who's the applicant?
Fiordland Charters Limited.
In terms of para 3.92, so you're referring to policy coast 2. We talked about maintaining and enhancing public access, and there's a theme sort of throughout around this public access. And I guess what I was interested in your view, is whether you take public access to mean access to each mooring, or because or is it access generally to the CMA? So I guess often deal with coastal projects where it's the access is actually about how you allow public to get from the land to the CMA so they can get in and enjoy the CMA.
Yeah.
But that's obviously not this situation.
I mean, it could even be the shoreline, enabling access. It's pretty broad, from what I understand, around the coastal marine area more generally, rather than a specific mooring and access to that mooring.
Yeah.
Muted itself.
Just working my way through. Well, I think that's pretty much all I had. Thank you. So is there anything else you wanted to cover in terms of conditions? Are you comfortable other than the condition 4?
Yep.
Are you comfortable with the others that you've recommended?
Yeah, I am, and I do have something to say about condition 4.
Yep, that would be helpful.
I recognise it's if you want to be super precise, it'd be nice to have precision. But
I do like to be super precise.
I get that.
Surprise you.
I get that.
What
I will say to the advantages of being a little bit more broad is that it can be multiple solutions to a problem.
Yeah.
And we've discussed that, certain scenarios are specific to that scenario, and there can be a different solution in each case. And I want to enable the flexibility to explore the different solutions that could be available. So having the wording as they are, I think still works, even if it doesn't mean mooring up alongside a boat, as I mentioned earlier. Accommodating another vessel could be helping them find a location elsewhere in that anchorage, or wherever else that suits, or even enabling them to stay there in the interim, which is an option in the toolbox, but not the only option.
Do you think there's some merit in, even if that wording stayed and you just added such as to give, and then list a couple of things that might apply, just to give us context? Because I think the concern I have is that the applicant actually didn't understand what that meant.
Yeah, okay.
So,
well, I would say that,
I
mean, there is condition 5 underneath, which says that the consent holder must keep records of any time it moves another vessel on from mooring authorised with consent. This record must be available. Now, maybe that could be something where we explain the solution that was found to meet condition 4. But I'd say condition 4 and 5 are interrelated to a degree in terms of, okay, let's find a solution. Maybe we should record that solution down, and then you have a compliance history of the different solutions that were found, and then the different options that may be available.
Okay, anything else on conditions?
That's really all I have to say.
Thank you for your report and for your response. It's very helpful. Right. Did you feel comfortable for me to ask you about precedent?
Yeah, sure. Yes.
So I think you heard the question presumably from Mr. Hodgson. Is there anything you'd like to contribute to that discussion?
Through you. I guess in my experience working on mooring resource consent applications, probably what I'd noticed, the proposals are often quite different. Different locations, different vessels, different mooring arrangements, different scale and intensity of use. Also different types of use, tourism, fishing, recreational, whatever it is, scientific, another one. So in my opinion, I don't think there is a precedent effect. The proposal's discretionary activity and future applications need to be considered on their merits.
Thank you. All right. Anything else? So
Sorry, that was me nodding.
that was you nodding.
Yeah.
There is something else.
Well, just to, if I may, Commissioner, because you said I might be able to have something to say about precedent if you
Oh,
could
yes.
as well.
Well, I wondered if you wanted to cover that in your reply.
Yeah, I can do that. But maybe one thing that might be good to say here, which will also be in the reply, just
Yes.
while we're in the room, talking about condition 4, and just by way of explanation, I think you've gathered there was a misunderstanding about that condition, which was brought over from the Fiordland Charters mediated settlement. And Mr. Cameron has explained for his boat when he said that, they wouldn't entertain another boat mooring up alongside is because of the weight restrictions and limits on the mooring itself. And
Okay.
so if that would,
Can't take more than your.
you can't, because then you wouldn't be covered for insurance. And it's also a completely different vessel in terms of Fiordland Charters. So that clause was specifically designed for Fiordland Charters, bearing in mind they might well accommodate someone mooring up beside them. So I think, I'm happy to look at a change to the wording. The other problem with the condition is it does talk about that mooring. I agree with you, Commissioner. I think it's better to have precise wording that is clear to an applicant and the compliance team. So I just wanted to give you a heads up. That was sort of where we were heading with that thing.
No, that's helpful. What I was going to suggest in terms of that condition, it does seem, I think I'm right, that really the only condition that seems a bit unclear is condition 4. So which is a great position to be in terms of like no one has to go and do a whole lot of rewriting. But what I was going to suggest is that as part of your reply process, you work with Mr. Hodgson and also the 2 submitters who attended today.
Sure.
And just get some feedback on some amended wording. And then when you come back to me, then I don't think we need 2 reporting steps. I'll be open to your views on this, but my suggestion is we don't need 2 reporting steps because it'll just take longer. Better off you coming back with your reply, including an updated set of conditions, and you can note whether there was agreement or disagreement from the submitters. And in fact, if you conclude Te Marama in that as well, considering their request to be part of any conditions.
Yeah.
There was one other condition.
Condition 10, Mr. Cameron talked about where it required twice yearly inspections, and he's explained that isn't efficient, economical, or necessary. So that would be once a year.
So Mr. Hodgson, did you have a view on that?
No, I think that's fine. I also recognise that these moorings are only really used heavily for 5 months of the year. So with that in mind, I think it's reasonable.
Yeah. And the only other condition that's been suggested by a submitter was Ms. Malloy around non-tradable. I have a feeling I know what your view will be on that.
I mean, it's a right of transfer under the Act, so it would be, an odd thing for the applicant to agree to not be able to exercise that right. I can tell you now.
Is there any views on that, Mr. Hodgson?
No, that's right, no.
You don't think that's appropriate? Thank you. I think that was the only one I had noted down that submitters had suggested. So I assume you would like to do your reply in writing? Yes. So have you had a thought about how long you might need to do that?
Well, I think it depends on whether you've decided you need further information from the Harbour Master, because if you did, then we'd need to see that.
Yes, I think I'm comfortable with the amount of information I've got on that.
Great. Yeah. Okay. Well, we can turn a response around pretty quickly. It just depends on if you were to direct a certain time frame by which we were to draft and send out the conditions, which wouldn't take long at all, and a response time frame from the other parties, that would be really helpful. So then there's no, if people don't respond by a certain date, we're not waiting around.
What I usually like to do, I mean, it depends a bit on if it's difficult, parties can't get along, but I'm sure you can all get along. You obviously know it. You obviously have been here a few times before. What I would prefer to do, if possible, is actually just agree with you on a date. You'll get the reply to me.
Okay.
And leave you guys to work it out. And the obvious point is that if people aren't responding, that's fine. That's
Yeah.
So unless, if you would like me to, I can set out a schedule, but I'd probably I don't know, do you have a view on that? I mean,
Look, we don't generally, as a principle, don't set hard timelines for this sort of thing. We choose to work with people under these circumstances.
Yeah. Is that something you're able to assist with if there was some conditions drafted? You'd provide a comment if you wanted to? Yeah, thank you. All right. Well, look, I think we've got the goodwill from the people in the room. So the issue we do have is around my decision timeframe. I've been advised that the decision basically due to the overall statutory timeframes is due on the 1st of December, which is pretty soon.
It is, actually.
So
From when you close the hearing, though.
well, no, the issue is that I have 15 working days from when I close the hearing. However, the overall timeframe that council has to process and issue their decision because of when the hearing is versus the notification is.
Oh.
So I would presumably the applicant could give approval for an extension. Yeah. So I guess that's just putting that out there that I'm actually quite happy to move quite quickly on this, but it does depend on how quickly you can get back to me.
Through you, Madam Commissioner, that's required to do it within 100 working days or something, isn't it?
Yeah.
So we'd have to, okay, well, so then you backing back from that, you setting enough time so that we've got enough time and you've got enough time to write the decision. So how many working days is that from today?
10.
Oh, really?
13 working days.
Pretty
tight.
Just from the decision before working days close, it's 13.
Yeah. Oh, look, we can, I'm happy to move quite quickly. I mean, if you were to say, I mean, we can get the conditions out in the next couple of days, I would have thought. And then, so what's today, Tuesday?
Look, I'll be open with you. I'm actually away most of next week. So
Okay, so if we have,
why don't we say, if you can get it through by the 25th.
Just to wait this week.
that's right.
Yeah, so we can get this.
Yep, and that's,
So 25th of November.
so by then we have our closing submissions
And but as long as you don't introduce any new information or anything, keep it as narrow as you can.
Yeah.
And then I can do my very best to get a decision out by the following week.
Okay, so by the 25th of November.
And that gives you a little bit of time to back and forth with
Yeah.
your submitters and council. Okay, so to be clear, the expectation is that the reply will be back by the 25th of November. Within that time, the applicant will lead pre-circulating conditions and provide the submitters and Mr. Hodgson an opportunity to comment. I would be comfortable for you to provide those to the Harbour Master as well.
Okay, the conditions.
Yes.
Okay.
Yeah, and if there's any concern, the risk with that, though, I just want to make sure you're okay with that, because the risk is that if he's not able to raise anything new.
Yeah.
So even had, there's no new issues to be raised, but it would be worth just if you think it's appropriate for him to cast his eye over them in terms of workability.
Yeah, sure.
Not a merits argument.
No, I get that.
Do you understand? Are you okay with that? Okay. So providing the submitters an opportunity to comment, and if you can just collate any feedback from the submitters as part of your reply, that would be fabulous. Thank you. Excellent. Okay, is there anything else?
I don't believe so. I'm happy.
Thank you.
Great. I will adjourn the hearing. Thank you to everyone who attended. Thank you for answering all my questions, and look forward to your reply. Thanks very much.